On this day, the 27th of February, 2023, I welcome all members here at M46 and on the virtual platform. I welcome the public protector and the legal team led by Advocate Mpofu here at M46. The evidence leaders, advocates Bawa and Mayosi, members of the media with us, our entire support staff, as well as the members of the public joining us for our continuing inquiry. Today, we welcome back the witness who would have taken an oath before, Ms. Mvuyana, who's with us here physically. You are still under oath. We wouldn't have to repeat that exercise. Welcome back. Would have paused at a time when we started with you on an issue of a statement that has subsequently been attended to. And as I recognize and invite Advocate Mpofu to start the proceedings with you, welcome back again, and over to you, Advocate Mpofu.
Thank you very much, Chairperson. Chairperson, I wanted to start by dealing with certain issues to do with witnesses, both the outstanding witnesses and if you remember last week, there was also the issue of whether Mr. Linda, the driver, would be called by either Ms. Bauer or myself. I'm just mentioning that, Chair, because that's what I intended to do. But because of time, Advocate Bauer and I have not finalized those discussions. So in due course, maybe after tea, can I deal with those practical issues once we have some kind of understanding? Thank you. Good morning, Ms. Mvuyana. If you can press, yes.
Good morning.
Thank you. All right. I'm going to be asking you questions, probably for the day. And
yes, I forgot to indicate that. Thank you, Advocate Mpofu. Advocate Mpofu would have the day with you. We hope that he will spare some time and finish by tea, but he has the day. Thank you.
Yes, now we'll finish by tea tomorrow, Chair. Thank you. Okay, ma'am. So we'll see how it goes. And so what I'm going to do is, as I indicated, I think when we started last week, I had said that I was going to start by giving some introductory remarks, not for long, and then I will ask you specific questions. But I thought it might be appropriate, you know, they say Black people always start a speech with an apology. So I thought we'll start by apologizing for the two false starts that we had in your case. And also to thank you for coming here physically. We know that that's quite demanding, but we also prefer to have the hearing remotely, but that just exposes us to all sorts of things, like being muted. So at least when we're here, we're able to have a decent hearing. Now, I'm going to, in this, hopefully, as I always say to the chair, when I make these opening remarks, it's really to try and contextualize your evidence, okay? And hopefully then it saves time. So we waste a bit of time at the beginning in order to save time, because otherwise we can be here for the whole week chasing something that is not pertinent to this inquiry. Well, as a legally trained person yourself, I'm sure you've heard of the favorite statement of lawyers that context is everything, correct?
Correct.
And so these remarks they'll be punctuated by a few questions are meant exactly to do that. Maybe I should just ascertain from Ms. Bauer. I'm assuming that normally she would have given me an indication of which paragraphs in your statements are not in contention. But I've done that exercise for her. So if she hasn't done it, she can confirm. I'm assuming that paragraphs 1 to 15 are not in contention, maybe with the possible exception of paragraph 8. You don't have to respond immediately, Advocate Bauer, but when I start with the questions, you can just check if that is correct. But even though that is so, I want to just confirm that you hold an LLB degree, correct, ma'am?
Correct.
And you joined the Public Protector in 2013 as a trainee investigator at the GGI, so-called GGI unit.
Correct.
Right. And broadly speaking, we'll come to this. Broadly speaking, you are here. There are various reports which form part and judgments which form part of this committee. You did not take part in most of those. You only took part in the so-called rogue unit investigation, correct?
Correct.
Of course, you took part in many other investigations, but as far as those relevant to this committee, it's the so-called rogue unit or SARS unit investigation, correct?
Yes, that's correct.
All right. Okay. Now, with that, then I'll make my opening remarks, Chairperson. And some will be directed at you, Ms. Mvuyana. The most important thing for the sake of context is that, and I want you to keep this in mind, this committee is not seized with determining whether or not there was a rogue unit. It's either there was a rogue unit or there wasn't. The work of this committee is different. If we were to establish the existence of the rogue unit, we would be here all week. You understand that?
Yes, I do.
Okay. This committee has been given certain judgments, and in particular with the rogue unit 1, there's a judgment, excuse me, which was handed down by a court headed by Judge Bakwa, who is himself a former public protector. But putting that aside, so that's the judgment that is pertinent, and that judgment is judgment number 48521. Sorry, Chair. It's 48521/19 of the Gauteng division. You are familiar with that judgment, correct?
Yes, I am.
Okay. Now, here's the most important thing, which unfortunately has been missed in this commission, in this committee. Again, this committee, unlike what the evidence leaders have said, that the judgments are binding, and I think some of the members or most of the members operate from that incorrect premise that the judgments are binding to the committee and therefore they are what they purport to be. We hold a different view on that, but that's a matter that will be argued at the end. We hold the view that this is an inquiry. And I think maybe people don't know what the meaning of an inquiry is, but you can also maybe assist us because you are an investigator. And in a way, you are also an inquirer. If indeed, would you agree, and this might be relevant to when you talk about the other investigations like KPMG's, Kakane, and so on. So if you were doing an investigation or an inquiry, but you consider yourself bound by some other inquiry or investigation, then would there be any point in doing that inquiry? Because after all, you are bound. You get where I'm going with this?
Yes, I do.
Yes. So the mere fact that we have something here called an inquiry into these judgments means that the committee must do exactly that, inquire into the findings that are made. Otherwise, we're wasting the taxpayers' time here because the judges have spoken. We should just spend one day to verify if there are judgments and then we go home. You understand?
Yes, I do.
Do you agree with that approach?
Yes.
And am I right that you yourself have said in your statement, for example, that despite there being several reports which had made findings, adverse findings on the so-called rogue unit, you did not regard yourself as bound by them. You still conducted your own inquiry and came to your own conclusions, correct?
Correct.
Okay, well, we hope then that the committee will learn something from that approach. But let's put that aside of what an inquiry means. Yeah. Also, this inquiry is not about so much about the impeachment or non-impeachment of the public protector, although it's related to that because that is the work of the National Assembly. This committee is really seized with inquiring into something much simpler, which is the veracity of the allegations of misconduct and incompetence on the part of the public protector as made by one Ms. Natasha Mazzoni, MP, and subsequently adopted by the majority of members in the National Assembly, mainly made up of the ANC and the DA. But Ms. Mazzoni being the sponsor or the complainant, are you familiar with that history, General?
Yes, I am.
Okay. Now, let's take, for example, the issue of competence here. So there are those who come here believing that because the judgments have already pronounced on the issues of incompetence, for example, therefore, it follows automatically that she must be incompetent. Now, if you approach the matter from that point of view, that there's a pronouncement of her incompetence and you are bound by that pronouncement, that would be tantamount to coming here with a predetermined outcome, wouldn't it?
Yes, it would, sorry.
And again, I want to refer it to your own experience. So if you came to the rogue unit, so-called rogue unit investigation on the basis that, well, Mr. Sikakane has already found that it's unlawful, and therefore it must be unlawful, you would also be approaching the matter with a predetermined outcome, correct?
Correct,
And that would be disastrous, correct?
correct.
All right. Because, as you know, again, as a lawyer, surely you know that holding a predetermined outcome for a process that's supposed to be fair, whether it is this committee or the public protector, is one of the most serious affronts you can have to our constitution if that process is supposed to be fair, correct?
That's true, correct.
So we shouldn't even waste the time of the taxpayers or this committee. If indeed the public protector is a person who approaches, or you as an investigator, or Mr. Mataboge, or anybody in your team who approaches an investigation of this seriousness already with an outcome in mind, or one that you think you are bound by, then you might as well not be called the public protector, correct?
Yes, correct.
In fact, I can tell you personally, I would be the first one if it was true that the public protector just looks at your face and decides whether you're guilty and then investigates. I would be the first citizen of South Africa to say she should be impeached, and I'm sure you would too, correct?
Just a pause,
Sorry,
Advocate Mbofu,
yes, Chair.
just a pause. Advocate Bauer.
Yeah, I didn't want to interrupt Advocate Mbofu because he said he was making some preliminary remarks, but he is leading the witness. And it is his witness. It's not ordinarily so that he's entitled to ask leading questions and solicit a correct answer indirect. He's not cross-examining this witness.
Thank you, Advocate Bauer. Please keep yours on. Please keep your mic switch on. Thank you. Advocate Mbofu.
Chair, I'm really, I mean, these are, I've not even started asking the questions that I want to ask. I asked for your indulgence for me to make these opening remarks. And if you want me to make the opening remarks without reference to the witness's own experience or statement, then I'll do so. But I think it's better if I kill two birds with one stone, as I'm trying to do. In other words, making my remarks, but also relating that to what she has said in her statement, by the way, that she did not, what to call it, regurgitate or cut and paste those other reports. So, Chair, if you allow me to continue like this, I will, but I'll be mindful that when I come to the content issues, then I ask the questions in a different style.
Okay, let's proceed in that way for now. Advocate Bauer.
Thank you, Chair.
Proceed, Advocate Mbofu.
Thank you, Chair. All right, maybe let me do it like this, ma'am, so that indeed I'm trying to save the time of the committee by whatever I'm saying, not just saying it in the air, but situating it within the realities of this committee. Let me do this, maybe to make it easier for Advocate Bauer. You have indicated in your statement, and I think it's common cause that the key charges which are relevant to your testimony, or the other way around, to which your testimony and that of Mr. Matabuche is relevant, are mainly charges 10 and 11. So I'm just getting a reference to the charge sheet, Chair. Okay, let me, just for the sake of completion, while we are looking for that, I think you've already said this, but just for the sake of completion, you are not here to testify on anything to do with the CX investigation, correct?
Correct. No.
You are not involved there.
No, I was not.
Neither are you here to deal with the Friede investigation. And by that, I mean Friede 1. You are not involved in that either, correct?
No, yes, I was not involved. So it's
Yes.
correct.
And therefore, you are really here for charge 4. And charge 4 has got two broad elements. The first one is what we call the HR issues. We'll deal with that later. That's the issue of victimization and harassment and so on. You will assist the committee insofar as you can, simply because you are an employee there. And if these things were happening, you either might have seen them or experienced them, but we're not going to go too much into that. You understand that?
Yes, I do.
Yeah, so that in our language here is charge 10. That's the one
Okay.
that deals with harassment, victimization, and intimidation. So mainly you are here really for charge 11. So it's 10 and 11. And 11, Chair, if I may read it, I apologize, we haven't put it up yet, but I just don't want to waste time. Oh yeah, it's bundle A, page 1 to 11. Simple.
Yeah, in the meantime, Ms. Mvuyana, if you could just shift towards this end and use that mic, because you're going to spend the whole day
Yeah.
looking at that side. It's going to be better for you to do that.
Yes. And also, thank you, Chair. Also try to speak into the mic because your voice is a bit soft.
Noted.
Thank you.
Just lift it.
Okay, just roll it up a little bit, Tsepo. I just want for the heading. Can you roll it up a little bit for the heading? Yeah. So that's charge number 4. You see that? And it has
Yes, I
two
do.
components, 10 and 11. 10 is the one that we just spoke about, harassment and what have you. So we'll talk about that later in your evidence. And then 11, as I say, is the core charge that you are here for.
Yes, I am.
Okay. And 11.1, you don't have to worry about that. And 11.2, something to do with the legal costs, you don't have to worry about that. So the main charges that pertain to you are 11.3 and 11.4. And let me just read them out. It says that African Koban is guilty of misconduct in that she committed misconduct by and or demonstrated incompetence in the performance of her duties by, let's jump 11.1, 11.2, 11.3, failing intentionally or in a grossly negligent manner to conduct her investigation and or to make her decision in a manner that ensures the independent, impartial conduct of investigations. And or and these two things are connected. So that failure is by deliberately seeking to avoid making findings against or directing remedial action in respect of certain public officials, while deliberately seeking to reach conclusions of unlawful conduct and impose far-reaching disciplinary measures and remedial action in respect of other officials, even where such conclusions and or measures and or remedial action manifestly had no basis in law or in fact. Again, as a legally trained person, I want you understand what the gist of that allegation is.
Yes, I do.
That it is not so much, as I said earlier, about whether some report is correct or not correct, or whether there's a rogue unit or there's no rogue unit or whatever. It's about the public protector deliberately, and yourself, I suppose, and other people in your team, deliberately saying that there are certain public officials who must be targeted, against whom there must be a vendetta to find them guilty, no matter what the evidence says, but no matter what the facts say, on the one hand. And then there are other public officials who, no matter what the evidence says, no matter whether you even have a picture of them taking money from the till, must not be found guilty. That's actually, that's why that's an impeachable offense. You and I will agree, correct?
Correct.
If it was indeed so that here there are two public officials, one is called Minister Heron, other one is called Minister Minister Gondwe. And so the accusation is really this: Minister Heron, because he's the favorite, it doesn't matter. You can have a video of him stabbing somebody, but the public protector will not find him guilty. Meanwhile, Minister Gondwe, because she's not our favorite, could be as pure as snow, but if anybody accuses her of something, she's going to be found guilty just because it's her. That's really what the essence of this impeachment charge is. You understand that?
Yes, I understand.
Right. Now, let me tell you then that in this particular inquiry, the people who fall under the Minister Heron category, the untouchables who will always be absolved, are, according to the evidence presented to this committee, people like Mr. Ace Mahashule and Mr. Musebenzi Zwane. So it is said that the public protector had evidence against them, but absolved them. You've been following the inquiry, correct?
Yes, partially.
Partially, yes. And then the other people who fall under the Minister Gondwe category, according to the evidence here, are Mr. Godan, Mr. Cyril Ramaphosa, and to some extent, Mr. Pillay. So those are the people that, according to what keeps us here for the past 7 months or 8 months, those are the people against whom it doesn't matter if they've done nothing wrong. You and the public protector and Mr. Matabo and the people at the public protector will always find them guilty. You understand that?
Yes, I understand.
Right. So that's the essence of why you are here. It's not about whether there was a rogue unit or not. It's whether that theory of the evidence leaders, or rather, I'm sorry, of Ms. Mazzoni is sustainable. In which case, as I say, if it is, then I'll be the first one to agree that to agree with Ms. Mazzoni that there should be an impeachment. But let's inquire into that. All right. Now, let me start by saying this, Chair, and I'm now getting into the meat. Would you agree as a general proposition that if there was indeed such a conspiracy to target, in the pursuance of a vendetta, people like Mr. Ramaphosa or Mr. Godan or Mr. Pillay, at least insofar as that pertains to the rogue unit, so-called rogue unit investigation, you would have to be part of that conspiracy, correct?
Yes, for it to work.
To succeed, yes. Yeah. In other words, remember, you are not facing impeachment proceedings. It's really the public protector who's facing impeachment proceedings.
Yes.
But for her to be guilty of this heinous offense envisaged in charges 11.3 and 11.4, it would be impossible to carry it out without enlisting the co-conspiratorial cooperation of people like yourself and Mr. Mataboga, correct?
Please explain conspirators.
Yes.
Conspirators.
Okay. No, let me simplify it. That it would be, let me ask you one question before. You, according to what I consider to be the non-contentious part of the statement, you were the investigator in the so-called rogue unit investigation, correct?
Correct.
Now,
Just try and raise your voice as you respond,
yes,
so that we
please.
clearly get it on the record.
Yes, please, because the majority of the members are online. So I'm sure if we are struggling being here, then I'm sure they're struggling even more.
I'll try my best.
Good, thanks. And in fact, that's good. Also be as close to the mic as possible here. All right, now let me, I'm just going back to, instead of using those big words, to break it down into. So you are the investigator, right?
Yes.
Now, just explain to us as if we were coming from Mars, how that works. Because remember, us and the members of the public, the things that you might take for granted because you work there are not generally known out there, correct?
As far as I'm aware, yes.
Yeah. So please then assist us as members of the public and as members of the committee. So am I correct that in a team of an investigation of this nature, you would have, let's call it on the ground, at the ground level, as we say out there, would be someone like you, that's the foot soldier on the ground, the investigator.
Yes.
In a typical investigation, I know it didn't apply to this one. The next level would be, you would be reporting to a senior investigator, correct?
Yes.
That's number 2. That person, the senior investigator, then reports to a chief investigator, correct?
Yes, that's correct.
The chief investigator reports to the executive manager, correct?
Yes, correct.
The executive manager reports to the COO or sometimes the acting COO, depending, correct?
That's correct.
And then the COO reports to the public protector and DPP. Let's just say the public protector.
Yes, that's correct.
Okay. So that's the point I'm making. So therefore, these 5, sometimes 4, sometimes 3 steps are the people, including the public protector, who would have to be part of this conspiracy to condemn the target of the vendetta, correct?
Yes, that is correct.
Yes. Now, and I want you to say this very clearly to the committee, because I think it's not understood. The person or the people who actually do the investigation work are the investigators in that chain that I explained, not even the EM, really. Let's say it would be the investigator, the senior investigator, and the chief investigator. Those are the people who do the nuts and bolt investigation, correct?
Yes, that's correct.
Yeah. And therefore, I'll put it as strongly as this, that it is, would you agree, the public protector will, when she testifies, explain this as well in detail. But I just want to test this with you because I can't call you after the public protector, so I have to take advantage of you being here now. She's going to tell the committee that, and put it as strongly as this, it is impossible, literally impossible for her to carry out this kind of conspiracy that she's being accused of if she did not have, I don't know, to bribe or recruit or get people like you and the senior investigator and the investigator to be part of that conspiracy. Will you agree with her?
It would practically be impossible to recruit without recruiting us
Yes,
to achieve the conspiracy.
absolutely.
Yeah, that's correct.
Thank you. Right. So in a way, then you are, I'm sorry to say this, in the dock as much as she is, yeah. Because you would have, for this thing to be sustained, you would have to be in on it somehow, or at the very least, maybe turn a blind eye, you know, wink, wink kind of arrangement, even if you were not a full-time member of the conspiracy, but certainly you'd have to overlook certain evidence, correct?
Yes.
Yes.
And also be in agreement.
With the conspiracy.
Yes.
Yes. Right. That I pressed the wrong button, sorry, Chair. No, excuse me, I didn't intend to cough aloud. Yeah, sorry, ma'am, you'll forgive me, I still have a lingering flu. Right, okay, so we've done and in this hierarchy that I've explained, I'm not even counting other people like the quality control people and those kinds of people. I'm just counting the management people. But obviously those people would also have to turn a blind eye to these glaring anomalies, correct?
Yes, but they'd only see those anomalies when they receive the draft report.
Correct. Okay. No, fair enough. So by then, obviously, maybe some of the concealment would have already happened. Is that what you're saying? That they may not necessarily have to be members of the conspiracy because they may only encounter it at the time of the draft report.
Well, the draft reports would detail the investigation process. They are not involved in the investigation process.
Right.
So they'd have to overlook, clearing anomalies.
And
Yeah.
deficiencies.
Yes.
Yes, thank you. All right, well, that's what the public protector is accused of. But in truth, then the foundational stone or the foundational stone of this conspiracy would have to be the investigator, because you are the person who's unearthing things, requiring things, and asking questions or suggesting which questions should be asked, correct?
The person who would actually be, if I'm understanding your question correctly, are you saying that the person would actually have the conspiracy as the investigator? So would have bias against?
Yes, the person would be the implementer, let me put it that way, of the conspiracy would have to be the investigator.
But then where did the conspiracy come from?
No, it comes from the public protector. Let's say on this theory, the leader of the conspiracy is the public protector. But I'm saying for her to execute it, the investigator, and I don't mean you, any investigation. The investigator is the person who's involved with the actual spade work of that investigation, correct?
The investigator is involved in the spade work. If they are in agreement with the public protector to have a conspiracy against a certain individual, then the investigator will carry out the spade work, inclusive of anyone that's in the team,
Yes.
hypothetically speaking.
Yes. Yeah. No, we're still there. Believe me, we think this is all hogwash. Yeah, but I'm just talking the hypothetically. Yeah, as you correctly point out. Okay. Now, okay. So now let's move then away from the mechanics of what it is that the public protector is being accused of. And let's now go to the so-called evidence that has been placed before this committee. I've already explained to you that that evidence, quote unquote, is primarily in the form of court judgments.
Yes.
You understand that? And I told you that there are two schools of thought as to whether those court judgments are cast in stone or whether they are susceptible of being inquired into. The evidence leader and the people like Honorable Mulder and others believe that those judgments are cast in stone and are binding as such at face value. Now, again, as a legally trained person, you would know that the judgments, the judges didn't just wake up one day and make those findings. Those are based on the evidence presented to them, correct?
Correct.
So the real source of the accusations, whether it's bias or dishonesty or conspiracy or what have you, the real source would be the people who brought that case to court. Those
Yes.
allegations, making those allegations against the public protector, correct?
Yes, the people who made the application, yes.
Yes. And in the case of the so-called rogue unit report, I will show you later, those allegations came primarily from Mr. Godan. You're aware of that?
Yes, I am aware.
And you're aware that Mr. Godan was also the applicant in those cases that led to those judgments, correct?
Yes, the rogue unit judgments.
Yes. And that Mr. Godan then made various allegations, including accusing the public protector of being part of state capture and corruption and what have you. In other words, the basis for that so-called conspiracy was political motives and all sorts of things. Are you aware of that?
Yes, I do recall.
Yes. And in fact, you would be aware that Mr. Godan made those allegations, in fairness to him, even in the response to your Section 7(9) inquiries.
Yes, Section 7(9) notice.
Section 7(9) notice, yes. And therefore, that's really the source of this conspiracy theory that has brought us here today, correct?
Allegedly.
Yes. In other words,
Didn't get that. You were
Says-
saying?
No,
allegedly.
I say allegedly because
Oh,
it's not the only charge, I believe.
yes.
Okay.
Yes, yes, it's not. No, okay, maybe let me, maybe I didn't ask the question properly. Confining it to the so-called rogue unit related charges. Is there, all right, let me put, as between the judgments and the statements made by the people who make the statements in the affidavit, such as Mr. Gordhan, which of the two is the basic source of the allegations? Is it the judgments or is it the people who brought the cases to court?
It is the judgments. Because the people who brought it to court, there were two judgments. The first judgment was setting aside the remedial action or interdicting the remedial action. And then the second judgment then set aside the report.
Yes.
Obviously, the reason for those reports was because Mr. Gordhan made an application to court alleging the allegations that you said that the PP was biased and that the investigation was not conducted properly.
Okay. Okay. Then your answer then is okay. It's twofold here. You and I need you to clarify it now. So what is which of the between the judgments and the Mr. Gordhan, let's put it bluntly here. Who is the original source of the allegations of conspiracy?
Mr. Gordhan.
Thank you. And therefore, if we are here to inquire into those allegations which originated from Mr. Gordhan, is it possible or conceivable or logical that Mr. Gordhan can be said to be irrelevant to the inquiry into his own allegations?
No, he made the allegation, so he should support his allegations.
Right. Thank you. Anyway, that is unfortunately the view of this committee, is that somebody like that, who's the real origin of these charges, is quote unquote irrelevant. But that's a story for another day. It's the same with Mr. Ramaphosa. Now, while you are there, in your statement, you say that correctly, that the three persons who were the primary focus of the so-called rogue unit investigation were Mr. Gordhan, Mr. Pillay, and Mr. Mahashula, Mr. Opa Mahashula. Do you confirm that?
Yes, I do.
And you then say in that order. So can you explain what you mean by that? Who was, of those three, who was the most important source of the or focus of the investigation and source of the allegations in the charges?
If we had to say main, would have been Mr. Gordhan. The first allegation relating to the report was a violation, an allegation of the violation of the emir. that can only be investigated against the minister, of course. I think we are all aware that who the complainant was. So the public protector was then bound to investigate that complaint. So Mr. Gordhan is the only person that the allegation was made against there. The second portion of the investigation, so that's the other issues related to Mr. Gordhan in relation to the fact that he was the former accounting officer of SARS. And that was how he then became almost a center. Yes. The second order, which would have been Mr. Pillay then became the commissioner after Mr. Gordhan became the Minister of Finance, I believe. After Mr. Pillay left, it was then Mr. Makashula. So they were the accounting officers who were involved in the alleged maladministration and improper conduct.
Okay, thank you.
Just a pause. I see a hand. Honorable Ngola.
Yes, thanks, Chair. Can you hear me?
Yes, we can hear you.
Thank you. No, Chair, I just wanted to add that we use full names of statutes or whatever, and not abbreviations for the benefit of the public. I'm sure.
Just repeat that. I missed that. I didn't hear you.
I wanted to add, Chair, that we use full names.
Full names. Okay.
Not
Right.
abbreviation for the benefit of the public, because I think a lot of people would not know what a mayor is in its full context. Thank you.
Yes, thank you. Thank you.
Okay, thank you, Honorable Ngola.
Yes.
Advocate Mpofu, over
Yes,
to you.
noted. Thank you, sir. I'll do it once, and then if I say a meal afterwards, then thank you, Honorable Ngola. But I just wanted to say we'll come back to the EMEA point here, just to round up the point that you've just made. The judgment, I want to refer to the judgment, I think it's bundle A 4016, if I'm the so-called rogue unit judgment. That's case number 48521.
Advocate Mpofu, the full bench or the bilateral judgment?
The full bench.
It's bundle C. Number 3. It's judgment number 18.
Number 3, 118.
No,
18.
18, 18.
18. Thank you. Thank you. Anyway,
Yeah.
Chair, again, to save time while they're looking for it, I'll just read it out. Oh, there you are. Okay, just go to paragraph 1.
Can switch off, Advocate Bauer. Your mic. Thank you.
Okay.
Switch on your mic, Ms. Mvuyana.
Thank you. Yes. I just want to say that, yeah, it looks like at least the chart.
Switch it on.
On.
Yours must stay on. Thank you.
Yes. I just wanted to say that I wanted to round it off. The judges seem to agree with you, at least on this, on what this whole case was all about. The very opening paragraph of the judgment says the following. On 5 July 2019, the public protector released a report, quote, on an investigation into allegations of violations of the Executive Ethics Code by Mr. Pravin Gordhan, MP, as well as allegations of maladministration corruption and improper conduct by the South African Revenue Services, called the report. Then says, apart from the adverse findings made against Minister Gordhan, the report also implicates Mr. Viswanathan Pillay and Mr. George Ngakane Virgil Magashule, the latter both former employees of the South African Revenue Services, in serious misconduct, maladministration, and criminality. So does that accord with your understanding of what this whole business was all about? That the report implicated Minister Gordhan, Mr. Pillay, and Mr. Magashule. And as I say, they are also listed in the order that you have just described.
Yes, I do.
Right. So according to then this other theory, it's possible that Mr. Pillay can be relevant, but Mr. Gordhan, who's number one on the list, can be not relevant. But as I say, that's a matter that we will discuss at another stage.
Sorry, relevant to?
To this,
To
to
the
the
inquiry.
inquiry, yes.
Oh.
I mean, to this inquiry. Or to the issues that brought you and all of us here. Now, you've also said that as far as the sorry, Chair, you've said that as far as what later we will call part one of the, or maybe let me do it like this. Is it correct as stated in your statement, and I think it's common cause because it was also put to Mr. Matabucha, that you received the complaint, or at least one of the complaints, from a Mr. Shivambu, who's a member of parliament, correct?
Yes, that's correct.
Right. And it's a requirement of the EMIR Act that, for Mr. Ngola's benefit, is the Executive Members Ethics Act. You agree that's what EMIR stands for?
Yes.
It's just the abbreviation. Yeah. It's a requirement of that act, Executive Members Ethics Act, that the complaint must come from a member of parliament. It can't come from me or my attorney or my learned colleagues.
Yes, that is true.
Yes. And you've already said it must also be against a member of the cabinet.
Yes, or a member of parliament.
Or a
Whichever
member of
works for you.
parliament, yeah. Actually, no, I think it's the
Member of parliament, like me.
no.
Thank you.
No,
Please attend to that.
yeah, no, member of parliament like Mr. Chanchi, if he doesn't get to be part of the reshuffle that is mooted, he would not be a target of a mayor, correct?
No.
Yes. Well, we might be saved by the gong. But be that as it may,
Committee has got important work to do, and it will continue and complete its business
thank you, Chairperson.
with the chair. Thank
Yeah, well, then there might be an EMIR investigation. But all right, now, so insofar as the report, the what you call the investigation was split into two parts. The first part, which dealt with EMEA and other things, we'll come to that. Of these three people would be focusing specifically on Mr. Godan, correct? The EMEA part.
Yes, the EMEA part
Yes.
was specifically on Mr. Gordon.
Yes. And therefore, insofar as the allegations of the conspiracy relate to the EMEA part, they would be originating specifically from Mr. Godan again, correct?
The conspiracy.
The
To make a
conspiracy
finding.
allegations, insofar as they are sought to explain the EMEA investigation. In other words, it's a sham investigation, it's a fake investigation, it's driven by political considerations and all those things. As far as that relates to the EMEA part of the investigation, those would emanate from Mr. Godan.
Yes, they would.
Yes. Right. All right. Now, oops. Sorry, Chair. Okay, Chair, I've just misplaced a document, but I'll improvise. Now, let's then get to the judgment. We've spoken about the Section 7(9) notice. And I'm going to take you through that in much more detail. But just for the benefit of the members, can you just explain what a Section 7(9) notice is? Briefly.
Okay, Section 7(9) notice is an interim report, as it used to be called, that is issued before a report is finalized. So it offers whoever is implicated in the investigation or whoever has to implement remedial action an opportunity to respond. So either on the findings that are being made against them or on the remedial action that they would have to implement. And that's basically it. It's an Audi alteram partem process.
Right. In other words, for those of us who are not as familiar with this as you are, can I simplify it like this? You do an investigation, you make adverse findings against me based on your investigation, and then you have to send me a Section 7(9) notice so that I have my Audi alteram partem opportunity to refute your findings.
Yes, the possible findings that will be made if you do not provide other evidence.
Yes, as you said, the provisional findings.
Yes.
Now, those provisional findings, depending on my response, if I say to you, well, go and jump in the lake, they might then translate into actual findings.
Yes.
Scenario 2, if I give you a complete explanation of that, no, this is not what it looks like. It's because, you know, I know in your report, you say, I had this bottle here next to me, therefore it looks like I might have stolen it, but I've got a receipt where I bought it and what have you, and here's the receipt. Then you find that your provisional findings will then go away, correct?
Not 100%, it's not guaranteed unless you do provide evidence that shows that you actually have the slip. But now we still have to compare if the slip is actually yours, did you pay for it? And then we then make a determination based on that.
Right.
So we still have to analyze the evidence that you would have provided as well before making any finding.
Very good.
It's not guaranteed that the
It's not
finding will
guaranteed.
be.
Okay. But if even after that, then I not only provide the slip, I even provide that, you know, video evidence of me buying the bottle, and it's clear that I have 100% explanation, then your findings would not be adverse, correct?
Yes, that's correct.
Yes, yeah. So that's scenario 2. And then scenario 3 is I say, yeah, well, I know that it looks like that bottle, but yeah, I mean, all bottles look the same and so on. So I don't give you something 100% concrete, but I give you some explanation which you don't accept. Then, of course, the findings, your provisional findings in that scenario might also be confirmed, correct?
Yes, they might be confirmed.
Right. Okay, fine. Then now we know what section 79 is and what its purpose is. Okay. Now, before the thing I was looking for, just I'm sorry to jump back to that. I just wanted to tie that up. In that paragraph that I showed you in the judgment, is it correct that Mr. van Lochenberg is not mentioned?
Yes, in the paragraph is not mentioned.
Okay. And you've said in your statement that the theory that Mr. van Lochenberg was an implicated person, yes, thank you, is false.
Yes, it is.
Yes. Why do you say that? What was the role of Mr. van Lochenberg in this, if he was not an implicated person?
In our investigation, we focused on the conduct of maladministration and improper conduct. So when the finding of maladministration and misconduct was made against the accounting officers or the former accounting officers, based on the fact that they are the decision makers and took the decisions that were taken in terms of the report. So Mr. van Lochenberg, yes, was a part of the alleged unit or alleged SARS rogue unit, but did not take part in any decision making. So that would be in the establishment, in the recruitment of staff, which were mostly a higher level. Procurement of equipment, he would also have played no part. So he would not have approved memos granting approval for SARS to actually go ahead with those purchases or implement certain decisions.
Yes.
Yeah.
Thank you. Because I think there's some confusion about that. Thank you. And is it also correct? And again, we'll go to the actual section 79 notice. Is it? Is it? Is it also correct that Mr. van Lochenberg's involvement was more located in what was to be known as part 2, in other words, the deferred part of the investigation?
Yes, the allegations made against him directly were referred to part 2.
Yes. And as far as the chairperson, just for the from Mr. Ngola's
No, I think you have firmly placed the understanding of EMEA.
Yes,
fully,
no.
so you can continue using
Using EMEA.
shortened version.
Yes, no, I will, Chair, but
Unless
I
there's a new one you thinking of.
no, I was just saying for in case Honorable Ngola forgets, it's in paragraph 16 of the statement. It's put there in full, Executive Members Ethics Act, and then in brackets EMEA. So then I agree with you, Chair. Then from now on, I think I'll feel free to just call it EMEA. There, paragraph 16, that's the one on the screen there. Thank you.
Matter is closed.
It's closed now, definitely, in writing. And there in that paragraph, since we have it, I'm just reading it for completion because you've already made the point. You say Mr. Godan played a central role in the investigation due to the fact that as a minister, he was the only person who could be subjected to EMEA, as well as being the former accounting officer of SARS. His conduct was therefore the primary focus of the investigation, especially part 1, which was the subject matter of the relevant report and the judgment which forms part of the charge or motion. That confirms what the evidence that we've just gone through, correct?
Yes, it does.
Right. And just for the sake of completion, so that we don't go back to this, from that evidence, you're also saying, apart from being a minister, which he is now, or he was then when you were doing the investigation, he was also primary because he had been the commissioner for SARS, and therefore the accounting officer in terms of the PFMA in that respect, correct?
Correct.
Yes. Now, you talk about maladministration. And again, I think it goes back to the point where we started this morning, that these things are not so much about whether there was a rogue unit or even whether a rogue unit, so-called rogue unit or investigation unit or whatever you call it, whether it is a good thing or a bad thing. Am I correct that yours was merely to find out if there had been breaches of, for example, the PFMA or any other law?
That is correct. Also, I think it was covered in the report that the intention of the public protector is not to stop anyone from doing anything. If we were to specifically talk about the intelligence unit now, that the SARS can have a unit that is obviously going to investigate taxpayers that are non-compliant, etc. Our main focus was whether or not legislation was adhered to in the conducting of those operations, especially in the establishment of the operations. And that was based on a complaint that we received.
Yes. Yeah, no, we'll come to the complaint, but I think this is an important point to make. So let me think, I'm trying to think of an example. Let's assume then that this whole investigation was about the most benevolent and the most important thing. Let's say the securing of ambulances for elderly people, okay? Which is a good thing. Yours was not to check whether the ambulances for old people is a good thing or a bad thing. Yours is to check whether the procurement of those, in the procurement of those ambulances, were the prescripts followed, the PFMA, whatever, the Ambulance Act, or whatever it is. And that's all really. You don't get involved in the whether it's a good thing or a bad thing situation. Correct. Thank you. And when we get to the report, Chair, that point is very specifically made in the report itself. All right. And while we are there, We might then as well for the committee break down the various aspects of the unit that you are looking at. And maybe you can explain in your own words. The first one, if I read the documents, was the establishment of the unit, correct?
Yes, the allocations.
What does that mean, the establishment? What were you looking into there in short?
The formation. So we were looking at the request that was then written to Mr. Trevor Manuel, who was the Minister of Finance at the time. The operations, so the kind of responsibilities that the unit had, and how would they achieve those. That would basically be the establishment.
Okay.
Now,
what else did you look into apart from the establishment?
what else? Oh, you
Yes.
mean the other allegations?
Yes.
So it was also the procurement,
Okay.
alleged procurement of equipment for that particular unit.
Okay, just a minute. So the second leg would be procurement of equipment. And
Yes.
in that, what would you be looking at, broadly speaking?
Procurement processes that need to be adhered to in terms of the PFMA and National Treasury regulations. Memos that were drafted and we obtained that were supposed to have been obtained approval, what the equipment was for, etc., that would have been contained in the memos. That was the kind of things that we usually look at in procurement matters.
Yes, good. What else? What was the other leg that you looked into in this specific?
Part one.
Yes.
The recruitment processes.
Okay, just a minute. Recruitment processes. Okay, under that leg, what kind of things would you be looking at?
In that leg, the kind of evidence that we would request or that we'd look at as well. Adverts for the positions, memos detailing the need for the positions, what was the reason for the positions being created, CVs, application forms, qualifications, memos as well, indicating interview processes, who would be appointed and why they appointed. So that would include your scoring sheets, who would be in the interview panel, and appointment letters. Yeah.
Right. Thank you. And that would involve HR policies, the applicable
Yes.
HR policies and so on. Good. Any other leg?
The second to last leg was the operations of the alleged unit was also looked into. In that instance, the evidence requested and obtained would have related to the operations of the unit. So how they conducted their activities and who conducted those activities and the reasons for conducting those activities. Yeah, basically.
Thank you. You know, I think that's gives us the landscape here. Now, when it comes to, no, it's fine. I'll take you through these four legs or so when we traverse the section 7.9 in more detail. Mr. Godin, the allegations against him of these legs, which one was, or which ones were more relevant to him?
Allegation 1, EMIR is already established that. Allegation 2, the establishment. Yes.
Of the unit.
Of the unit. Allegation 3, the procurement. And allegation 4 or D of the report, which is the recruitment processes.
Recruitment, okay, fine. Okay, and let's not get into detail, but those were pertinent to him, or rather, he was relevant to those allegations.
Yes.
Okay, all right. Now, you went into a lot of detail. I think you say in your statement that this investigation was done in a very thorough manner.
Yes.
Can you broadly just support that statement?
In my understanding and my explanation of thorough, the processes of the investigations of the public protector were followed. So at the beginning of an investigation is consultations, meetings, assessment of the complaint, trying to understand what the complainant is trying to say. In this instance, we even met with the complainant who had a very detailed complaint and very long complaint as well. We met and he explained and qualified all the allegations made. Thereafter, we wrote to SARS. With relations to the EMEA part of the investigation, we were required to write to the president to inform him that we had received a complaint from an MP against Mr. Gordhan. We also wrote to Mr. Gordhan informing him that we have received a complaint and these are the allegations made. We listed all the allegations. We received responses from both SARS and Mr. Gordhan, except, of course, the president is not required to respond. Those documents and received from both Mr. Gordhan and SARS were analyzed thoroughly. So when I say thoroughly is that we actually sat down and looked at the document and not just skimmed through the documents or and actually applied our minds, because I remember that one of the allegations is that we didn't take into consideration a particular 2014 or 2016 matter. So in that instance, once SARS notified us that there was an investigation previously done by the PPSA, we went and looked for the file. I personally went. We found the file and found the response of Mr. Pillay at the time. I think it was it's a 2014 letter. That was also considered. What was relevant to our investigation was considered, and we began then issuing subpoenas or trying to get the main role players to provide answers in terms of what we had discovered and to provide more information, etc. Subpoenas were then issued to Mr. Magashule, Mr. Pillay, Mr. Gordhan, and we tried to also subpoena a response from Mr. van Locherenberg, mainly for the operations part.
Yeah.
Everyone responded. So everyone being Mr. Pillay, Mr. Gordhan, Mr. Magashule responded to the subpoenas that had been served on them. Once we had received the responses, we went through them and incorporated them into what evidence that we had already began jotting down, because we don't just sit with evidence, we have to actually put it on paper so that we can get a picture of what actually happened here. Once that was done, we then discussed the matter in length with the relevant officials, that being the team. Once that was done, I think everyone has seen the emails to and fro. Once that was done, the Section 7(9) was issued to Mr. Gordhan, Mr. Pillay, Mr. Magashule. We then awaited responses from them. Responses were received. the investigation was finalized.
Yes, thank you very much. Chair,
you.
if you can bear with me and maybe take the break 5 minutes late. I just want, because I'm going to take you in detail through the Section 7(9) statement, which really, I think, succinctly encapsulates what would be both your version and the version of the public protector. So again, it kills two birds with one stone, because when the public protector testifies, she will also use that as her blueprint of how you did this. But you've just summarized broadly how you went about doing what you call the thorough investigation.
Yes.
But the reason why I'm asking the chair to give me the indulgence so that we can do that when we come back from the break is because I just want to kill one issue which arises from what you've just described. A lot of heavy weather has been made about the failure by the public protector to serve a subpoena on Mr. van Lochenberg. And again, I want to preface this by making it clear of what exactly she's being accused of by Mr. van Lochenberg and others. Again, it's not so much that she did not serve the subpoena on Mr. van Lochenberg or her office did not. That's common cause, right? What is really being alleged is that non-service, and that's why we're here in an impeachment room, for lack of a better word. It is that lack of service was not, it was an act, it was deliberate. In other words, the public protector or whoever, you or someone else, specifically went out of their way to ensure that Mr. van Lochenberg does not get the subpoena in the pursuance of the grand conspiracy of making findings against Mr. Gordhan because he is one of the people who must be condemned no matter what. You understand that?
If I may ask before you continue,
Right.
What's the connection between Mr. van Lochenberg and Mr. Gordhan?
Yes. Okay. In this theory of mine. Yes. Okay. No, it is this, that in order to falsely condemn Mr. Gordhan, one of the things that you and the public protector had to do was to make sure that you do not get information from Mr. van Lochenberg, because Mr. van Lochenberg was the head of the unit. And if you had gotten the information from him, you would have realized that this whole thing is just nonsense. So you actively and deliberately wanted not to hear from him. Do you understand the theory? Again, it's nonsense.
Yes, I understand.
You understand it, yes, okay. So that's the real issue. So it's not so much about service or non-service. Yeah. Now, firstly, I'm going to ask you that what steps did you take to ensure that Mr. van Lochenberg is subpoenaed? Because you just counted him among the people. You say you did your thing, you spoke to the complainant, you looked at the document, you listed what I think you called role players, or maybe you used another word. And he was one of those role players, and therefore you subpoenaed the role players, including him. What steps did you then take to ensure that you don't just serve the subpoenas on the other 6 role players, but deliberately hold back on this one of Mr. van Lochenberg, as it is alleged? What steps did you take?
Okay, I'll just start with in any investigation, that I have conducted, and I think most of my colleagues, Mr. Kortan, Mr. Pile, and Mr. Mahashul. I'll start with them first because they were the ones that actually received the subpoena.
Yes.
Mr. Kortan, we had his contact details. When you Google Minister of Public Enterprises, you get the email address of the PA. You can call the PA, easy access. We even have the attorneys of record that usually respond on his behalf. So, and there'd been previous investigations. So another colleague would have easily given me his contact details. That same goes with Mr. Pillay and Mr. Mahashul. The information was readily available within the institution of the PPSA. Now, Mr. Van Locherenberg, as the investigator, I'd never met him. I don't know him. I just know that he was an employee of SARS. So once that was done, we then discussed with Mr. Matabuche as the supervisor, hey, we need to find this guy. So this guy being Mr. Van Locherenberg, and we need to find out how we're going to serve him. We don't have an email address for him. We don't have a cell phone number or a telephone number, and he has resigned from SARS. Luckily, or yeah, I'll say luckily, we had just met or had already met with a whistleblower who was within SARS at the time when we were conducting the investigation, requested to remain anonymous. When we were then trying to figure out what to do, we then resolved that, no, let's call. Should I continue or wait?
Yes,
Sorry,
continue.
I'm sorry.
Continue. Don't be disturbed about the body
Yes.
languages.
No, I
Just
was
continue.
trying to attract the attention of Advocate Bauer, but I'm not succeeding. It's fine. I'll talk to her during the break here. Okay. Sorry, brother.
Please proceed.
All right. So we met with a whistleblower who was within SARS, employed at SARS, in the HR division. Yes.
Don't reveal too much.
Yes, but no, I want to reveal that because they had easy access to getting that information. SARS is a big institution. Some people didn't even know or still don't know Mr. Van Locherenberg within SARS. So we contacted Mr. Anonymous or Miss Anonymous, and they then provided us with the address. The person who called Miss or Mr. Anonymous was Mr. Matabuch, due to protocol.
Yes.
Yeah. So I was provided the address. I drafted the subpoena, provided the address. We put the address on the letter, our letterhead, which then submitted to the public protector for signature. So all four went together for signature and came back signed. It was then the three were emailed to the relevant parties. So Mr. Pillay, Mr. Kortans, and Mr. Mahashul were emailed. And then because we don't have an email address for Mr. Van Locherenberg, when our whistleblower / Miss or Mr. Anonymous came back, they just had that address and stated that there was nothing else on the personnel file. So they did not have a telephone number or forwarding address that they had on record at SARS. So we then took the address. We do, and we have to serve subpoenas physically. We use the services of Mr. David Linda at the time, who was a driver / messenger. I requested Mr. Linda to go and serve the subpoena. Mr. Linda agreed and he went to serve the subpoena. He asked, because he usually asks if he's going to serve, if he can have the cell phone number of the person that, and we stated that, no, we don't have a cell phone number for this person. Just let's go try this address that we received. He then went and came back and said, no, he couldn't find Mr. van Locherenberg. He said he'll try again tomorrow. He went the next day and then came back with the fact that Mr. van Locherenberg was not in that address and had either moved or had never even, we're not sure what happened, but yeah, what he told me was that we'll never find that guy. That's what the caretaker told him, that we'll never find the guy, even if we wanted to.
Okay,
Yeah.
right. Now, okay, thank you for that.
That's where our 5 minutes take us.
Okay, okay.
Yeah,
That's fine. That's fine. Yes, that's a good point, Chair. I'll ask you one more aspect on this and then we'll move to the 7-9. Thank you, Chair.
Thank you. We will take a 10 minutes break and back at 10:02. Thank you.
Recording stop.
Lochenberg, Ms. Mvuyana, please settle. We have to be patient and wait for you because
Yes.
there are just about 3 of us or 4 in this room that don't have a luxury of walking up at any time. So we only need a break to do. So we can't start without you. So I hope you're now ready to proceed.
Yes, I am. I apologize.
Okay, continue sipping your tea, that's fine. Over to you, Advocate Mpofu.
Thank you, Chair. Thank you so much, Chair. Yes, just wanted to round off the issue that we were discussing before the break. You had established the efforts that you had taken in order to trace Mr. Van Lochenberg, starting from his previous employer and then following on that lead, then Mr. Linda going again the following day and so on. But I now want to ask you 2 related aspects. One is, and that's really what is relevant for the committee here. Of the people in the team, and I'm now talking about the team investigator, chief investigator, executive manager, public protector, you can even throw in the deputy public protector if you like. Of those people, whose responsibility was it, or is it usually, to serve subpoenas or to make sure that they are served?
The investigation team.
And that means who and who and who
In
in this case?
In this case, it would have been me, Mr. Matabuche, and Mr. Linda.
Yes.
Well, Mr. Linda, though, did not form of the part of the team. He was just providing a service for the team.
Yes. In other words, Mr. Linda, either at your request or Mr. Matabuche.
Yes.
But okay, let me put it this way, without being condescending. I'm not concerned about anyone who is below Mr. Matabuche.
Okay.
So I'm saying, okay, above Mr. Matabuche, is there anyone who would be responsible for the service of such subpoenas?
No, they wouldn't. We would just brief them that we're having difficulty or challenges, but they won't get involved in communicating with David, instructing David, etc. David being Mr. Linda, sorry.
Yes. And now let's stop beating about the bush. The accusation in this inquiry is that the public protector, A, was involved in this tracing or tracking exercise, and B, even worse, was also involved in the deliberate effort not to serve the subpoena. Is that even possible?
No, she is not responsible for tracing an individual that has been identified during an investigation that's done by the investigation team. We are the ones, like if I'm making an example from what I said previously, if we know that a certain investigator dealt with a Opa Makashulan issue or an allegation that related to him, I would approach, or Mr. Matabuche would approach that investigator, hey, do you have this guy's email address, etc. So public protector would not get involved in that. In relation to the deliberate, that PP would have deliberately not served Mr. Van Lochenberg, it's not possible for either of us to deliberately do that.
Yeah.
What would the motive have been? Okay, so, PP, it's non-existent, but I take offense to that allegation, actually.
Yes. Yes, no, I accept that. And I suppose that's a variation of the same theme, because for that to happen, you would have to be party to that deliberate non-service.
Yeah, deliberate,
Yes,
non-service, yes.
yeah. And can you tell this committee in no uncertain terms whether you or anyone that you know was ever party to a deliberate non-service to Mr. van Lochenberg?
No, definitely not.
Thank you. And just to make this abundantly clear, and please excuse me for the example I'm going to make. Let's assume you or Mr. Linda or Mr. Matabuch, the three people that you have mentioned. Maybe it's easier for Mr. Linda. Let's assume you gave Mr. Linda the instruction, and then Mr. Linda, instead of taking the subpoena, went to, and I hope he'll excuse me as well, went to some shebeen or tavern and decided to throw the whole thing into the dustbin, and therefore Mr. van Lochenberg was not traced for that reason. Is there anything that the public protector would have done, or could she even have known if Mr. Linda decided to do such a thing?
No, unless informed by Mr. Linda's manager.
Mm.
If they had discovered that, because now it would have to go, it would be reported to his superior that take the decision. Now it's a whole, HR issue. So PP, the evidence of that would have been where?
Yeah.
Unless someone saw him putting it into the bin.
Yeah. All right. No, it's fine. I'm just asking that for emphasis. And maybe let me put it like this. Once you or Mr. Matabuche informed the public protector that you had done everything in your power to trace Mr. van Lochenberg and failed, was she entitled to take your word for it, that you have done whatever efforts were needed to be done?
Yes.
Thank you. All right. Thank you. Right. Now, let's then go to yes, thank you. Okay, just got a note for the sake of completion so that we don't come back to this. It has been suggested, all sorts of things have been suggested, hindsight, as they say, is an exact science. All of us sitting here will be clever now because we were not in that space. It has been suggested that you should have done tracing through Facebook or social media and the internet. Did you consult the internet?
Yes, Google.
You Googled yourself?
Yes, myself, to try, and even before we approached the whistleblower from SARS, that was the first point, to find out if he had a more recent employment, etc. So that was Google. Unfortunately, we don't have access, or didn't have access. I don't believe we even still get it for Facebook and YouTube at the office.
Okay.
So the server doesn't allow those kind of
Applications.
searches, even LinkedIn, because LinkedIn is the more professional body of that. Yes.
All right. And I think Mr. Matabuche also brought another insight into this, in the sense that it's also been suggested that he should have been traced via some letter that came from his attorneys in June 2019. And Mr. Matabuche's evidence, if I'm not misrepresenting it, was that the tracing effort had been done in April already, and you had already given up and decided to proceed with the investigation on the understanding that Mr. van Lochenberg could not be traced. So by the time there was this June letter, that is it, the horse had already bolted. Can you try and explain that in terms of, the timeline of the investigation? Could it have been that he would have been traced in June, and what would have then that meant in terms of the sequencing?
On the 5th, I think the letter is the 5th of June, if I'm not mistaken. Just like to state that I've never seen that letter.
Yes.
It was not sent to me. I have no involvement in it. But at that point in June, the Section 7(9) had been issued. Besides the fact that the Section 7(9) had been issued, when we sat as the team to discuss what really Mr. van Lochenberg was required for, or was required to answer on, which were the allegations specifically of maladministration and improper conduct. Mr. van Lochenberg, if I can use the word role player again, wasn't a decision maker in any of the allegations or the findings that we were going to make or potentially make. And he wouldn't have been impacted as well on the remedial action that was going to be taken, specifically by SARS in relation to trying to resolve any issues or systematic things that we had identified during the investigation. So our viewpoint was that then, since Mr. van Lochenberg's allegations relating to him specifically, directly, which were the allegations that he had received funds into his personal account, were to be dealt with in issue 2. And that's when we would now restart the process of vigorously trying to locate him. So at that point, at June, Section 7(9) is issued. No findings are being made against Mr. van Lochenberg. His letter, I'm not sure what the letter said specifically. We were now in the process of collating all the information we have gathered. So I wouldn't know what would I have done now if I had seen the letter at that time, but I can't comment on something that did not happen.
Yes.
Yeah.
Thank you. So just to put the matter beyond any doubt, is there any basis for alleging that the public protector was responsible, or anybody or yourself was responsible for the deliberate non-service of Mr. van Lochenberg's subpoena?
No, but everyone has a right to an opinion.
Yes. And yeah, but we're interested in the facts.
Yes.
Well, we should be. I can't vouch that we are. As a matter of fact, was there any deliberate non-service on Mr. van Lochenberg?
No.
Thank you. Right. Okay. Now we can then go to where I wanted us to go for this session, which is page 6245. I think of the same bundle. It's the 7-9 notice. Tsepo, if you can find it, 6245.
Yes, you want? Page number, both.
6245.
It's a bit slow today.
Unlike her. No, sorry, I think I've misled you. This is all right, maybe you can help me. What-
Bundle. Is that what you're asking? Okay.
There can be many 6245, yeah.
Or just
But,
explain what it is, then we
okay,
can look
yes,
for
it's
it.
the section. No, wait. This is the section 7-9 notice for Mr. Pillay. Actually, I'm told that the same thing appears in bundle 8, 6472.
The check, is that the one? Just check on the screen.
Yes. Sorry. What's the date of that? Okay, just go to kindly, yeah. That's the document. Chair, okay, I'll just use this for practical purposes. There's a similar one for Mr. Godan, but they are more or less the same. This will be sufficient to make the points I want to make. Okay, let's just use this. You can confirm that you sent similarly worded section 7-9 notices to Mr. Pillay and Mr. Godan, as far as the background and all that is concerned, correct?
Correct, Mr. Pillay and Mr. Makashula would not have had the EMEA
Yes.
issue.
Yes, except for that. And I'll do the cross-referencing for the committee. I apologize, Chair, but I just want to use the one that I've underlined here. All right. Now, this is 5172. Okay, I'm told Mr. Godan's one is 5172, just for reference purposes. But I'm going to use this one. All right. Now, these documents, the 7 nines, I must say this as a by way of preface. For me, this is the biggest sign that this was a thorough investigation, because quite frankly, I've never written or seen many 66-page or 71-page letters. And this one to Mr. Pillay was 66 pages. What is the page number at the top? Tsepo? 6472. Okay, that's not my number. Okay, that's fine. So then I'll just use the paragraph numbers here. But that particular letter, Chair, just for the record, is 66 pages and signed by the public protector. It's, as I say, I've seen many letters, but not that the one that is that long. So we'll go through it. If we go through it bit by bit, we'll be here all week. So I'm just going to deal with the broad topics. So please go to the paragraph 3. Right. Okay, after identifying that there was a complainant by Mr. Shivambu, sorry, go back to paragraph 2. Identifying that there's a complaint by Mr. Shivambu and an anonymous whistleblower. And so the second complaint lodged on the 9th of November by Mr. Floyd Shivambu, the Deputy President and Chief Whip of the Economic Freedom Fighters. Then we go to paragraph 3. Yeah. Okay, and trying to move along with speed, then it details the actual allegations in those complaints, correct?
Correct.
And it talks about Mr. Pillay having failed to follow proper recruitment procedures in the appointment of Mr. Yolisa Piki and Mr. Van Lochenberg.
Correct.
Right? So again, there, it's not Mr. Van Lochenberg as much who's accused of anything. He's just the subject of the accusation. It's Mr. Pillay who's being accused, correct?
Correct.
Then the next one, again, is Mr. Van Lochenberg unlawfully received cash deposits paid directly into his personal FNB account and so on. And again, it's not like he paid anything. He received certain monies allegedly, correct?
Yes, correct.
And the same allegation is made against Mr. Makwakwa, that he also unlawfully received cash deposit into his personal account in the same way as Mr. Van Lochenberg, correct?
Yes, that's correct.
Allegedly, yeah. And then the point you made earlier, Chair, which is that during the tenure of former Commissioner of SARS, Mr. Pravin Gordhan, Mr. Gordhan established an intelligence unit in violation of the intelligence prescripts, and the intelligence unit was confirmed by SARS investigation report compiled by Advocate Kakan. Was that your understanding that the SARS investigation was actually commissioned by SARS?
No, this is the allegation. So the complainant will come and tell us that I want to complain against this, and we put it as it is.
Yes.
When we confine our own issues, we then will either confirm or not confirm whether it was Advocate Kakan who
Yes.
were commissioned. But yes, that is the allegation that SARS commissioned an investigation that was compiled by Advocates Kakan.
Yeah.
Who then confirmed.
Okay, then again, maybe just to assist the process, subject to any objection by Advocate Bauer, I think it's common cause that the Sikakane investigation was indeed commissioned by SARS, specifically by Mr. Pillay. Is that what you subsequently found?
Yes.
Okay. Right. And then there was another, excuse me for jumping to this, there was another investigation called the KPMG report, which we will also talk about. And I think it's also common cause that was also commissioned by SARS, but this time Commissioner Mvuyana. Was that what you found?
I won't recall because I can't recall exactly now, Advocate Mpofu. Because KPMG was in 2015, I believe. Yes, it was Mr. Mvuyana.
Yes,
Yeah.
thanks. Yes, because I think he started in September 2014. All right. And then, Chair, I won't go through all those allegations, but they cover really what the witness has already spoken about: the equipment issue, bagging of offices, recruitment, what have you. Up to 3.14. Then at paragraph 8, and this is an important issue. This is where the division of part 1 and part 2 is. This is by the public protector. She says, due to public interest, I have decided to focus the first part of my investigation into the following issues. The allegation that Mr. Godan violated the ethics code by deliberately misleading the National Assembly in failing to disclose that he had met with a member of the Gupta family since taking office. 8.2, the allegation that during his tenure as SARS Commissioner, Mr. Pravin Godan established an intelligence unit in violation of the South African intelligence prescripts, and SARS fails to follow correct procurement processes and so on. So that would be what became the so-called rogue unit report, part 1, correct?
Yes, that's correct.
And then at paragraph 9.2, paragraph 9, the following issues will be deferred to the second volume of the investigation. So that's part 2. And that firstly is the investigation about Mr. van Lochenberg, as you earlier testified, correct?
Correct.
9.2 is also the investigation that Mr. van Lochenberg received money into his FNB account. That was also to be deferred, correct?
Yes, that's correct.
Mr. Makwakwa and all those things, and IT tenders of 8 billion and what have you, all that was deferred, correct?
Yes. I'm
And then
not
if you
sure
go to,
about the IT tender.
um,
Is it on the?
yeah, it's 9.6.
Okay.
Just go to 9.6. It says the allegation that SARS irregularly extended the SARS IT tender for 12 years, resulting in fruitless and wasteful expenditure that has escalated to 8 billion to date.
Yes, correct. It's correct.
Yes.
Part 2.
Yes, that was all part 2. And then if you go to paragraph 10, it's a summary of what part 1 is. It's basically a repetition.
Yes.
So those are the 6 points of what was going to be actually investigated in. If you go to 10.1, please, 10.1 onwards here. It's just a repetition of those issues that are in part 1.
Yes, if I can, before you continue, the point that I was making, that the allegation in the list where the complaints are listed, you remember that allegation number 2, which relates to the establishment, at the end, the complainant says that this was confirmed by the Sikhakhane report. In the allegation that we then convert into our issue, it's no longer there. Yeah.
Okay,
Thank you.
fair enough. No, that's thank you very much. Yeah, I stand corrected. That's actually an important point. Yeah. So you are saying that the complainant might frame it in such a way that they've already reached some conclusion.
Yes.
But when you have to frame it for yourselves, it must be as neutral as possible.
Correct.
All right, good. So for that point, one would have to make a comparison between what is said in 3.4, which includes the Sikhakhane thing, and what is said in 10.2, which excludes it.
Yes.
Yeah, okay, good. Now, number 12 is then, as we explained earlier, I think to the chair and the committee, the nub of what section 7.9 is. And I'll just read it out. It says, I have evidence indicating wrongdoing on the part of SARS and Mr. Pillay, and in the Gordon letter, it will say Mr. Gordon, obviously.
Yes.
Mr. Pillay or Mr. Gordon, as a former employee of SARS regarding the allegations below, and should I not receive evidence to the contrary, I am likely to make adverse findings and take appropriate remedial action against SARS and yourself for the wrongdoing under the circumstances, mindful that you and the erstwhile commissioner who may have been responsible at the time for the commission of the relevant wrongdoing is no longer at SARS. So that's the heart of this document,
Yes.
as we explained earlier. If I don't get anything, remember my example about the bottle of water. If I don't get anything, I'm likely to make adverse findings against you.
Yes.
So this is your Audi opportunity.
Yes, correct.
Right. And then we come to what we call the investigation process. Then you outline to the person how you can't just say, I just got into, I'm likely to make adverse findings. You then have to explain to them how that came about.
Yes, you
Right.
have to.
Then the investigation chair, from 13.1. And again, I won't read everything. It's a preliminary investigation was conducted and so on. And then through 13.1.2, a formal investigation was subsequently conducted. And then number 3, I received information and documentation from different sources, including whistleblowers and complainants. I also utilized documents previously submitted to me by SARS for file number 7.2 of 2012. So you identify there that you got information, you did what is called a preliminary investigation. We'll go back to what that means now. Then you had a formal investigation and that you received information from whistleblowers and various other sources.
Correct.
Right?
Yes, that's what it says.
Right. Now, if you can, let's pause there, because this also covers another issue that also covers the so-called HR issues. What is the first thing you do when you have an investigation of this sort? Or maybe let me put it this way, what is involved in the preliminary investigation?
It would be meeting with the complainant or complainants, as well as doing the relevant research, finding out if we haven't investigated a similar matter before. Once we establish that, and also establishing jurisdiction, of course. So that is mainly what a preliminary investigation would do. Once we then confirm that there is a possibility that the allegations have merit, or that they are possibly true, we then start with the relevant institution to ask them to give us, to tell them that there are allegations made against that institution. So in this case, we wrote to SARS. Mr. Mark Kingon was the acting commissioner at the time, detailing all these allegations that are listed in this report and requested documents to support, or not to support, but to just either to refute the allegations. Yes, sorry, okay. English runs away sometimes. Or either confirm. So they are then submit either we prefer institutions to submit a formal statement. So in a form of a letter, it doesn't have to be commissioned or anything. In a form of a letter detailing the allegations, whether they deny or agree with the allegations that have been made. And then in whatever that they say, attach specific evidence. That is then the first stance. In this case, letters had to go out to the relevant parties. So that was Mr. Gordhan, Mr. President Ramaphosa, and then SARS. Those were sent, documents were received. We go through the documents, identify who needs to be interviewed, if we have to have meetings with them. If we don't understand certain things, it's not clear from the documents, we then call meetings, etc. Once all the information is collected, it's analyzed and put into paper. Now, no one knows what is going to be the end product until you finalize the analysis of the documents, because they are the ones that are going to tell you if something happened or something went wrong in whatever process that is being investigated. And those we then put in the application of the law, what should have happened or what actually happened. So the law will tell you what should have happened. Once you analyze that against the backdrop of the evidence that you have or has been submitted, that you obtained as well, you then make a conclusion. That's how then we get to a product of either Section 7(9) or a discretionary notice, depending on the outcome of what the conclusions say. Is that process fine, or you want me to continue?
No, it's fine.
Okay.
It's fine. Thank you. Just an important issue. You've said that one of the most important things you do is to consult or to interview the complainant.
Yes.
Okay. Now, okay, that again, I'm asking you now as an experienced investigator. You are now a senior investigator, correct?
Yes, correct.
Yes. Whether, and this is another thing that this committee and us have been at loggerheads about. Is it, if the complainant is available, let's assume the complainant is not a whistleblower or someone who wants to remain anonymous. Why is it so important that the complainant must? Or let me put it this way, is it possible to even proceed with your inquiry or investigation without involving the complainant, the person who actually brought us here?
Yes, it is possible. If the complainant is the complaint in his complaint form, excuse me, the allegations are clear, straightforward. They even attach supporting documents, evidence. That is, it's clear. You're not forced to meet with the complainant. It's your discretion as the investigator, whether or not you need further consultation. But consultation can also be done through the phone, through a telephone call. Yes. Now we even have Zoom, etc. In this particular case, if we go back to the evidence that has been presented, like the Section 7(9) states, there was a complaint received in October 2018. When you read that complaint, it's not very clear what the complainant is complaining about. So in that instance, you'd want to meet the complainant. No?
Yes.
I won't go into detail thereafter because the question has not been asked.
Yes. Okay. No, that's fine. And maybe, well, but it's been answered in your last part. Yeah. Let me put it this way then. Yeah. Where there is, as you say, lack of clarity or ambiguity or some controversy about the complaint, who is the best person to clarify that?
If the complaint is not clear.
Yes, let's say there's some controversy or debate or lack of clarity about the complaint itself. The point is there anyone other than the complainant who can assist you with that?
No.
Thank you. All right. Anyway, so you then did go to the complainant in this case, and when and how did you get to have a meeting with the complainant?
Just a pause, Advocate
Sorry, Chair.
Advocate Bauer.
Yeah, there's two complainants. Can you just clarify when Advocate Mpofu asked the question, which complainant is referring
Yes.
to?
Okay. Thank you. All right. I thought I clarified it in the qualification to my question. I was saying, apart from putting aside any anonymous whistleblowers or complainant who might not be identifiable or easily identifiable, but that's fine. What Advocate Bauer is asking, you have confirmed at the beginning of this letter in paragraph 2 that there were two complaints. One was anonymous and the other one was from Mr. Shivambu, correct? So
just put it on. Sorry.
Yes, that's correct.
So when you say you met the complainant, which of the two were you referring to?
Mr. Shivambu.
Okay, thank you. Mr. All right, the other questions I've already asked you. So obviously you wanted clarity or more information or whatever it is. Can you just tell the committee what happened in that meeting or what was discussed?
The complaint that he had lodged was discussed. So it took us into detail about his allegations. Unfortunately, we don't have a full record. And I don't remember making notes, but I did make notes. It's just I can't find them now. But basically his complaint, what his complaint was about, specifically what information he had in his possession that he could provide to us. He provided us with also names of people we can talk to for further information. Basically, that was it. It's just a prelim. It's not like we're interrogating the complainant. We are just trying to get some more information. And he was also a willing participant who wanted to give information. So it made our lives easier.
Yes. Good for you. Well, you should come and teach us in this inquiry that the importance of the complainant. Yeah. But again, that's a story for another day. Anyway, so there's also there was a suggestion at least made to Mr. Mataboge, and I suppose that's what Advocate Bauer is alluding to, that the other complainant, the anonymous complainant, I think wrote a letter to you or an email to say that he or she was coming to South Africa in December, but the meeting with that person did not take place. Can you explain why that did not happen?
The anonymous complainant. The anonymous complainant we received in October of 2018. So this is before Mr. Shivambu arrives, even though we didn't even know that he's coming. We receive a complaint. His complaint, if you can go through it, it's about 3 paragraphs. The first part, which was when we receive a complaint, normally we'll communicate with the complainant, informing them that, okay, the matter has been allocated to me for further investigation. In this instance, I required more information from the complainant, and I said to him, we respect the fact that you'd like to remain anonymous, but the kind of allegations you have made need more information, specifically in relation to the surveillance. The complainant was alleging surveillance of politicians and etc. So, and then the second allegation was that Mr. van Locherenberg had then received personal monies into his bank account, and he listed the monies. The third allegation, I believe, was about Mr. Gordon receiving monies in the United States or Canada, if I remember correctly. We then sent the complainant an email requesting that kind of interaction. He did not respond until we then received Mr. Shivambu's complaint. He responds, okay, once we see that this complaint relates to SARS, because what happens in the public protector is that if complaints come in at almost a similar interval, then they relate to a similar institution. We will then identify with, okay, these guys are, or these people are complaining about a similar issue. So the allegation, let's say Van Locherenberg receiving cash payments or cash into his personal bank account, was also contained in Mr. Shivambu's complaint. The complaint relating to surveillance or unlawful operations of the alleged unit was also in Mr. Shivambu's complaint. The decision was then taken, okay, yes, we are beginning the investigation. After meeting with Mr. Shivambu, we'll start the investigation because we've already had another complaint that's similar. So investigation proceeds, we write the letters, then we receive the email about the USA. The decision was taken. It was not necessary anymore. We had we'd gotten clarity of where he wanted to go, complainant.
Okay,
Yeah.
good. Okay, thank you. So in other words, you're saying the complaints were similar, or at least there was they might not have been identical, but there was overlap.
Yeah.
Okay. Thank you. All right. Now, then you've already explained this, what you call the formal investigation. That's when you require information from the role players.
Yes.
Sorry. Right now, then we go to paragraph 14, 65. Okay, let me not try to do the page numbers. Paragraph 14, yeah. Then you explain to the person the evidence obtained during your investigation. Remember, you said now we've done an informal investigation, a preliminary investigation, we've done a formal investigation, we spoke to whistleblowers. Now you then explain to them what information you received, right?
Correct.
Now, then you put the first allegation regarding whether during his tenure as SARS Commissioner, Mr. Kodan established an intelligence unit in violation of the prescripts, whether such conduct constitutes maladministration, right? And I'll just go through that particular one, but not all the other allegations, just to show your methodology, okay?
Yes.
You start, I'll just read it out, Chair, for the record. 14.1, you put, it is not in dispute that the allegations relating to the unlawful establishment of SARS intelligence unit has been one of much contention within the public arena of South Africa. The matter has been investigated and discussed by various institutions and legal experts. Various reports have been submitted to me regarding such investigations. Where did those various reports come from?
SARS.
Okay. And does that, we've already covered some of this. That would be the Sikakane, Kanyane, KPMG, Kruon, and then the legal opinions of various advocates. Okay, we'll come to that. Yeah. All right. Now, while we're here, you've been accused, when I say you, okay, maybe let me establish this so that there's no confusion. While this is a letter signed by the public protector, as it should, can you explain to the committee what role you personally played in its formulation, construction, drafting, all 66 pages of it?
I was the drafter.
Mhm. And well, congratulations. When you draft this 66-page letter or something of that sort, this would be now after you've done your investigation and you are at the stage as where you explained earlier, where you have possible adverse findings against somebody.
Correct. Yes.
Right. Now, so when I say you, although we know that the letter is signed by the public protector, I'm using that interchangeably, or it's a plural you and the public protector as the drafters or architects of this letter. All right. Now, one of the things that the public protector, including yourself in this context, has been accused of very sharply is that you did not take into account the findings of the Nugent report, Nugent Commission report, otherwise known as the Commission of Enquiry into Tax Administration and Governance report. Is that criticism valid?
No, it's not.
And did you in fact take into account the Nugent report?
Yes, we did. We mentioned it a couple of times and what the findings of the report were and the passing commentary that was made by the judge.
Mm-hmm.
So if we hadn't considered it, we wouldn't have even known what it says.
Yeah. And that, if you go to 14.1.4, and then I'll read you some of what is said here, and you'll then comment on whether the criticism that you ignored the Nugent report is valid. 14.1.4 says that in a response dated 5 February 2019, SARS stated that the consideration of lawfulness of an intelligence unit within SARS had generated a vast amount of comment and opinion. SARS referred me, that's the public protector or you, to the Commission of Enquiry into Tax Administration and Governance final report, specifically under the heading, the so-called rogue unit, in which it is stated. Well, firstly, let's just start with that. Another criticism by Mr. van Lochenberg was that the public protector was the originator or was guilty of prejudging by simply referring to this thing as the so-called rogue unit. Have you ever had anyone accusing Judge Nugent of the same thing? Because his heading here is called the so-called rogue unit. And do you know where that term came from? Did it come from the public protector?
I know the rogue unit comes from media reports as far back as 2014, if I'm not mistaken.
Yes.
I think it was the Sunday Times that initially broke the story, if there is a story.
Yeah.
So-called, I don't know where that comes from. I think it's a term that because there's been so much denial of the fact that the unit was rogue, people usually put so-called in front of it. Yeah. So no, it did not originate from the public protector. At the time of the response was received in February. No, we hadn't had a meeting with the public protector yet, where she would have been able to refer to the so-called rogue unit.
Yeah,
Yeah.
no, it's fine. No, it's fine. When the public protector testifies, she'll explain that actually when that term was constructed by the newspapers, she was minding her own business, working in China, not even dreaming of becoming the public protector. But anyway, such is life. Anyway, so this is the point about the report that you allegedly ignored. If you go to the next page, please, Tepo. There you quote extensively from the New Gen report. You actually quote 3 paragraphs from the New Gen report. Isn't that right?
Yes, it's correct.
While we are on that point, Chair, can you will come back to this, Tepo. Just move over to 14.2.1. That's now page 26. That was page 10 of the 66 page letter. Now we're at page 26, the typed page, 14.2.1. Yeah. There again, you say that SARS referred me to an extract of the SARS Commission of Enquiry, that's the New Gen report, which stated specifically regarding the alleged purchase of equipment, and then you quote the New Gen report again, you and the public protector, correct?
Correct.
Now, in the light of those, and in any event, I think since we're here, Chairperson, we might as well go to sorry, we'll come back to this. This one. Yes, just for the sake of completion. Sorry, Tsepo, can you go to the report, the actual report, which is, I think in bundle A, it's 4257.
You winning, Tsepo? You need directions. Okay, I thought he gave you.
Yeah, I did. It's page 4257 of bundle A. It's the report. It's the so-called rogue unit report. Starts at 4217 on my, yeah. Yes, thank you. Thank you, there you are. I'm just jumping all the other references to the Nugent report. I'm now taking this to the report itself, to the so-called rogue unit report. 5.2, can you go further down? Yeah. The public protector says in her report, SARS referred me to the Commission of Inquiry into Tax Administration and Governance final report under the heading, the so-called rogue unit, in which it stated, then she quotes the Nugent report. So is there any substance to the allegation that she ignored and did not take into account?
No, it's not correct.
Yes.
Yeah, we obtained a copy of the report. As you can see, SARS is just referring us to paragraphs. We then
Yes.
then obtained a copy of the actual report to confirm that what SARS is quoting here is correct. So that couldn't have been done without reading the report, specifically on the issues that related to the rogue unit, because there were a lot of things the Nugent report went into. So this is how we then considered it.
All right. Let's just pause there then to deal with something very central to this whole saga. And that is the point that you make in the report, or rather that the public protector makes in the Section 7.9 notice that you drafted. Where you say various reports have been, the matter has been one of much contention within the public arena in South Africa. The matter has been investigated and discussed by various institutions and legal experts. Various reports have been submitted to me regarding such investigations. Now, it's common cause that those reports include the Skakane report, the KPMG report, the Kruon report, and so on and so on. The allegation that is made against the public protector, and this also comes out from the judgments, the judgment, is that the public protector relied on these other reports. Apart from this kind of remark, which she makes by way of background, that there have been various other institutions and what have you. In other words, it is suggested that she literally almost transplanted information from those reports, regurgitated it into her report, and ignored the fact that those reports had been, quote unquote, widely discredited. I don't know by whom. Is that a fact? Is that what you did in actual fact?
No, that is not correct.
What role?
Just as a background, we as in investigations, when we write to, even if it wasn't SARS, another institution altogether, in some instances, you'll find that they've already conducted a forensic report or forensic investigation. That is submitted to us. We don't then take that report and copy and paste and put it in our report. We also, that's why we also request evidence. In instances, we'd even request the annexures that led to that particular forensic investigation company coming to that conclusion. So it is false. It's not how we work. It's not how we draft our reports. Thank you.
Thank you. And this theory goes further to say that not only did you regurgitate or blindly rely on these reports, you also ignored the fact that they had been discredited. Are you aware of any discrediting of these reports?
No, I'm not. The only one that I am aware through media was that the KPMG dilemma that they experienced. Yeah, but the fact that it is either credited or discredited doesn't stop the report from existing.
Right.
Yeah.
Now, let's just test some of what is said glibly out there about these reports. Maybe let me start with this Kakane report. Are you aware of any institution, court that dealt with or reviewed this Kakane report frontally and found it to be invalid?
Not that I'm aware of, no.
All right. And it's widely believed, at least it's been bandied about here, that Justice Nugent at least was one of those sources of the discrediting of the report. Let me just take you to the actual fact. Let's go to the quotation. Let's go back to the letter. I think it's easier that way. Let's go back to the letter. Sorry, go to paragraph where we were, paragraph 14.1.4. The quotation further down. Yeah. Okay, it's not nicely legible, but I think we can make do. Yeah. Thank you, Sean. This is what all that Justice Nugent said, and it's called discrediting the report. He says about the rogue unit alleged. Why such a unit was considered to be unlawful is not clear to me. So he says it's not clear to him, okay? And then he says, while the National Strategic Intelligence Act prohibits the covert gathering of certain intelligence, that applies to intelligence concerning threats to the safety of the state, which hardly applies to the intelligence relevant to collecting tax, okay? And then here's the part where he is said to be discrediting the finding, but actually, in my view, he confirms it. He says, that members of the unit might have at times have acted unlawfully, that SARS employment policies might have been breached, that members might unlawfully have acquired the use of equipment, all of which came later to be alleged. I see no reason why SARS was and is not entitled to establish and operate a unit to gather intelligence on the illicit trades, even covertly within limits. Okay, let's unpack what Justice Nugent is actually saying. So he says that, firstly, the last part you've already agreed with earlier. There's no reason why SARS is not entitled to establish and operate a unit to gather intelligence on illicit trades, even covertly within limits. We all agree on that, correct?
Correct.
Yes. But it's what he says before that, which is important, which everyone ignores deliberately. And that would have been the focus of your investigation. It's not something you just brush aside. Let's assume that he's right, that members of the unit might have at times acted unlawfully. SARS employment policies might have been breached. Members might unlawfully have acquired the use of equipment. Would that be sufficient for the public protector to find maladministration?
If evidence
If it
shows
was
that the
established,
might,
yeah.
yes, the might is where we come in because, yeah.
No, forget the might. I'm saying if that was established, that at times the members acted unlawfully, SARS employment policies have been breached, and members acquired the use of equipment unlawfully. Would that be sufficient for the purposes of the public protector to make an adverse finding of maladministration?
Yes, supported by evidence, of course.
Yes, okay. Now, and to your knowledge, did the Sikakane report, the KPMG report, and all these other reports find that the establishment, let's confine it to that for now, of the unit was lawful or unlawful?
And they found that it was unlawful, the establishment.
Yes. And in fairness to Justice Nugent, he then goes on to say at paragraph 11, just go further down. Yeah. Again, this is another statement whose impact is widely exaggerated. It says, it was said to be unlawful by a panel chaired by Advocate Sikakane, but I find nothing in his report to persuade me why that was so. So he expresses his opinion. And then he says, Advocate Sikakane was asked if he could elaborate on his reply and took it no further than what was said in the report. And then it comes to the Kruen report. It says that, okay, no, before we do that, just on this Sikakane report, if, let's say, Sikakane found that this thing is red and Judge Nugent found that it's blue, as the public protector, did you have the means to say that the Nugent report is more superior to that of Sikakane, or did you regard all of them in the same light?
They're all in the same light with respect to the public protector's investigation.
And of course, you take them into account, but would you regard any one of them to be binding on your own outcomes?
No, even on our investigation.
Yes. Okay. Well, then we.
We'll pause there.
Mm.
Unless you want 3 minutes. To
Okay, 3 minutes, Chair, just so that I introduce the next topic. Thank you, Chair. Okay, I'll try and move on this one fast. The other one is the Kruen report. Before we go to KPMG, we'll do KPMG when we come back. The Kruen report, its common cause was a panel, I think, of 7 members. And it also found the unit to have been unlawful. Now, this is what Justice Nugent says about that. Continuing there, the SARS advisory board chaired by Judge Kruen reported to the minister and issued a media statement saying the unit was unlawful. But in evidence, he told the commission that what a conclusion reached independently by the board, but had been adopted from the Sikakane panel. And he came to realized it was wrong. Indeed, he supported the re-establishment of capacity to investigate illicit trades, which we recommend. Yeah. So again, it's I don't want to say deliberate, it's a conflation of the goodness or otherwise of the establishing a unit from its activities. But apart from Judge Kroon himself expressing a view about the findings, are you aware of any of the other 6 members of that panel expressing a view that they had changed their mind?
No.
All right. Okay, then we'll go to KPMG after lunch, but
Maybe with us, so that I don't break it for you. We'll break it 15:15.
oh, thank you, Chair. Thank you so
45
much.
minutes, so
Yes.
you can go to KPMG.
Yes, thank you. Yes, then after lunch we'll start with the IGI report. Thank you. Okay, so very quickly, okay, Chair, I'm not misleading you, but I'll have to go back to Skakan. Can you go to bundle A, page 4681, paragraph 188, just so that we don't have to come back to this report.
What are you asking?
Bundle A, page 4681, paragraph 188.
Did you get it, Tsepo? Yeah.
All right, the Chair, I'm just making sure that I don't go back to this report here. These were the findings of Sikakane that we just discussed. I'll read it quickly, Chair, for the sake of progress. At paragraph 188.1, he says, they say, and by the way, these were 3 advocates, independent advocates, advocate Sikakane, advocate Rajab Badlender, and advocate Ramano. They say the establishment of the unit without having the requisite statutory authority was indeed unlawful. And then at 2, they say there is prima facie evidence that the unit may have abused its powers and resources by engaging in activities that reside in other agencies of government. And then if you jump to 188.5, says there is prima facie evidence suggesting that the activities of the Special Projects Unit may have included rogue behavior that had the potential to damage the reputation of SARS as an organ of state. Hence, after that, it was called the Rogue Unit, not by the public protector who was in China, but by those 3 advocates. You remember that?
Yes, I remember reading it.
Yes, reading it, yeah. And then if you go to page 4617, for 617, Chair, that's paragraph 56. Yeah, this is another important finding of Advocate Sikakane now to do with Mr. Godam. Uh, 56. Yeah, just look at the last sentence where it seems yeah, it seems, eh? Sorry, my glasses are failing me. It seems from the memorandum that Mr. Godam had an taking from NIA that it was willing to accommodate such a unit. It follows even on SAR's own version that unless NIA cooperated, the establishment of such a unit would be an illegality. You remember reading that?
Yes, I do.
Yes. So, and just to round that up, your own findings were that Mr. Godan must have been involved in the establishment, also based on the memorandum that he wrote to Mr. Trevor Manuel, correct?
Yes, that's correct.
All right, we'll come to that after lunch, and I just wanted, I don't want to jump to that now. Chair, this is the part which I wanted to get to before lunch. These are now the findings of KPMG. No. I said I'll do KPMG after lunch. Yeah.
We changed that, remember?
Oh, okay, fine. We can do it now. Yeah, so that we do IGI. All right, then go to please page 5084, Tsepo, bundle A, paragraph 12. 5084. Right, thank you. So these are the findings of, okay, just a minute. Yeah, paragraph 12 says executive findings and conclusions. This is now KPMG. And it says, under the guidance of Pillay, a covert and rogue intelligence unit in contravention of the rule of law was established in SARS. Remember that?
Yes.
And then 12.1.3 says this unit was established by Pillay at the time when Godan was commissioner of SARS. We found no evidence that Godan was informed of the existence of the unit. However, considering his position as accounting officer, it is reasonable to expect that he ought to have known of the existence of the unit. Remember that?
Yes, I think I do.
Yes. Now, is it correct that your findings were similar to these? In other words, your findings were that given the letter to Mr. Manuel, given the history, the evidence available, the idea that Mr. Godan was oblivious of the establishment of this union, or rather of this unit, was just unsustainable.
Yes, seeing that Mr. Godan drafted the memo or was the approver of the memo as the commissioner of SARS, the memo to Mr. Manuel.
Yes.
It's impossible that he didn't know. The memo details that we would like to create a unit. The unit will undertake specific kinds of investigations, and he then signs the memo. So how would he not have known that there is a unit?
Okay, and I don't want to stretch the chairperson's patience, but I just want us to end that part on what that memo actually says. Chair, if you just indulge me for 2 minutes. All right, that memo is referred to in your letter, but I was actually, I'm looking for the, okay, let me paraphrase this, we'll do it after lunch. Is it correct that in the memorandum drafted by Mr. Godan, he himself says that when he writes to Mr. Manuel, please approve of the establishment of this unit within NIA, because the SARS does not have the legal power or the legal mandate to establish such a unit.
Yes, in summary.
Yes. Can you go to bundle A, page 4370. I promise you that's the last reference I'm making. 4370. The same series, 4370. Ooh. Okay, let's try and read it together. This is a letter written by Mr. Godan to Minister Manuel when he was the Commissioner for SARS. Okay. One, the purpose is to seek approval to find a special capability within NIA to supply SARS and law enforcement with the necessary information to address the illicit economy. Move. Two, collecting, this is the important part, collecting tactical intelligence invariably, okay? Invariably means penetrating and intercepting organized criminal syndicates. You see that?
Yes.
And the whole part of this whole controversy is whether or not there was a need to do interception, in which case it would be illegal, or there was no interception, in which case it would just be some normal operation. Remember that?
Yes.
So he makes it clear that what he's asking for is something that will invariably means penetrating and intercepting organized crime syndicates. And then he says, this is the punchline. This is an activity to which SARS does not presently have the capacity, including the legislative mandate to manage.
Capability.
I'm sorry?
The capability.
Capability, yes, thank you, Chair. They have the capability, including the legislative mandate, to manage clandestine activity. And then it says, discussions are taking place with National Intelligence Agency to supplement SARS intelligence capability and so on. And the point I'm making is that by Mr. Godan's own hand, the unit was not, could not be legally established within SARS, correct?
Yes, correct. That's what the memo says.
Yes.
Mm.
And yet we know that, in fact, just go towards the end to the approval part. Yes, it's signed by Mr. Godan, Commissioner of SARS, 2007, the 9th of February. Go further down. Yeah, no, further up. Okay, no, that's fine, sorry, I misled you. There, yeah. So Minister Emmanuel approves, the Deputy Minister, the Deputy Minister Chabu Muleketi, then also approves, but he puts a rider. He says supported. However, this is a strange way of executing what I consider to be an economic mandate of NIA. If such is true, whatever, it is an add-on rather than part of NIA's mandate. Okay, but he approves it, subject to that. You see that?
Yes, I do.
Yes. Now, when we come back from lunch, I will then take you through to show this committee and everyone else that actually, after what Mr. Godan says, NIA lost appetite of that joint venture that was envisaged there. They then somewhere decided to just have that very illegal activity and have that unit now operating within SARS, which is what you and the public protector found. But can we deal with that when we come back? Thank you, Chair.
Okay, thank you. We'll pause for lunch for 45 minutes, back at 2:10. Thank you. We're now going to resume with Advocate Mpofu and Ms. Mvuyana. Thank you very much. Over to you, Advocate Mpofu. Is Ms. Mvuyana here first? Oh, okay. Okonago. That's fine. Thank you.
Thank you, Chair. Sorry, I just lost my place. Now, we were still using the letter, but digressing to some of the issues that are raised in the Section 7.9 letter. And I think we were now in the nub of the issue as to the findings regarding the existence or rather establishment of the so-called rogue unit. And just to recap, we had found that both KPMG report and the Skakane report had referred to the rogueness, if there's such a word, of the unit. Otherwise, I think that just means the unlawfulness, the alleged unlawfulness of the unit. And sorry. Sorry. All right, can we go to bundle A5189? All right, sorry, just go to the beginning of that document. Yeah. Okay, that document starting at, sorry, can I see the page? Starting at 5179, bundle A, that is the response of Mr. Godan to his Section 7.9 letter. Remember that?
What is the date of the document?
Okay, the date will be at the end, I suppose.
Yeah.
Okay, 17th May 2019.
Yes, I remember the document.
Remember the document, thank you. Okay, then let's go to, yeah, now 5189. Yeah. Now regarding the portion that we were debating, or rather we were discussing before lunch, it is where we left it where we established that Minister Godan, well, not Minister Godan, Mr. Godan, Commissioner Godan at the time, had made a request to Minister Manuel, which Minister Manuel approved with the concurrence of Deputy Minister Muleketi, on the basis that he wanted the establishment of a unit which should otherwise be illegal if it was established within SARS. Remember that?
Yes, I do.
Right. Now, this is now Mr. Godin's own version of the event, which makes it clear that they then went on to establish the the unit illegally within SARS. Let's just read out. Chair, it says here, it became apparent to SARS that it had to enhance its capacity to gather intelligence, that is information of and to investigate organized crime with particular reference to tax-related implications. SARS decided in about February 2007 to set up the unit to specifically investigate the activities of crime syndicates from a tax customs perspective as part of its efforts to combat activities in the illicit economy. Both the Minister of Finance and Intelligence Services in principle approved the concept to establish an investigative unit to focus on organized crime as a direct consequence of the 2000 State of the Nation address. The initial intention was to employ and train members of such investigative units on how to legally conduct tax and customs investigations, and then to transfer those officials to the NIA, where they would continue to function as a unit dedicated to support SARS investigation into instances of non-compliance in respect of tax and custom laws. And here's the important part. It says the NIA, however, did not pursue the matter further. As a consequence, SARS decided to retain the unit members within its enforcement division. Now, the importance here is that Minister Godin says that this unit, which should otherwise be illegal, was now then established within SARS, so the unit. So the unit hasn't changed its character. It hasn't suddenly become something else. It's still the unit that was being spoken about. Is that how you understood it?
Yes, that's correct.
Right, then carry on. Sorry. Then the section 209 of the Constitution is quoted. Carry on. Section 41(1)(a) of the Constitution is also quoted. That's the section that deals with cooperative governance. Carry on. Okay, sorry. All right. Carry on. Yeah, okay, let's just pause there. As I said to you that there were two features that would define this as an intelligence operation or not. And there were many other features, I suppose, but whether it was a spying activity or not a spying activity. But the most important was surveillance of people and interception of communication, correct?
Yes, that's correct.
And Chair, we will refer you just now back to the letter, but there is a specific reference, not just to the NIA Act. So I just forgot now what it's called, the full thing. But there's reference to another piece of legislation which deals with interception specifically. We'll come to it when we're in the letter. But just to paraphrase, is it correct that in South Africa, in any event, forget about NIA Act or whatever, if you want to intercept communication of any person, you must get the permission of a judge.
That is correct.
Okay. And was there any evidence that when there was alleged interception, that any permission was received from any judge?
No, not that not that was submitted to us.
Yes.
Yes.
And what evidence did you have of interception activities by this unit that Mr. Godan established?
We had a recording of Mr. Van Rensburg and Mr. Lombard. We also had a bit of information from the 2012 or 2016 complaint, but that couldn't be verified because it didn't have any supporting documents. So mainly it was the recording. If you notice in the letter, even in the report, that was the evidence that was put before the public protector. We listened to it. The two gentlemen confirmed that they had bugged offices.
Yes. Thank you. Chair, sorry, if I can just pause here. There's a typo, for lack of a better word, where the mistaken identity, maybe let me call it that. At paragraph 30 of your statement, you refer again to say Mr. Lombard and Van Rensburg, as you just said. And we've established, I think it's common cause, that it was actually Mr. Lombard and Mr. Duval. Is that the same gentleman who participated in the alleged spying?
There were various names that were given. I'll just have to double check if.
Okay, that's fine. We'll double check, but I'll speak
Yeah.
to my learned friend. But for now, let's use Mr. Duval, because I think that's the common cause person. All right. Anyway, you had evidence of Mr. Lombard and this other person doing what?
They stated in the recording that they had been called and had then went to the NPA offices, had a meeting with a certain individual there who requested them to bug offices of the NPA and
Yes.
formerly and also DSO. They agreed. This is what they said though. They agreed with the condition that they were going to still talk to their boss or supervisor, who they said was Mr. Pillay at the time. Mr. Pillay apparently then agreed, but there was nothing in writing. And they then proceeded to bug the offices and obtained a recording of it's something that happened there that was discussed. I would like not to say the names. Everything is contained in the report.
Yes. Okay. And if that evidence was indeed true, would that be confirmation or not of the existence of a spying unit, quote unquote?
It would have been because the two gentlemen were a part of the unit. So the recruitment records show that they worked for the unit. And it was possible that they then could have taken part in operations of the unit, which they claim is now intercepting information or gathering information illegally.
Yes. Now, again, as someone who's legally trained, you will know that the process of reasoning, of legal reasoning at least, is to infer a certain conclusion, you must have some concrete facts.
Yes.
Yeah. So you might, nobody will be able to enter into Mr. Godan's head and determine that he knew about the establishment of the unit. You can only infer that from the facts that are proven, correct?
Correct.
And in this regard, then, the letter that there's usually, as they say it in criminal law, there's a smoking gun. And the smoking gun means you find a body that is dead and a person with a smoking gun. And the reasonable inference is that the person with the smoking gun is the one who shot. There might be all sorts of permutations. Life is not that simple, but that's the kind of inference that you draw from the smoking gun to the dead body without actually having seen the actual shooting. You get where I'm
It's
going?
possible, yes.
Yes. So then let's say then that the letter to Mr. Manuel was the smoking gun, which was written by Mr. Godan, which says that the unit would be illegal, which asks for the permission. And when the permission is not given, then the unit is still established. Was that more or less the kind of reasoning that you used?
Yes. As he's saying in his response to the section 7.9, after NIA showed that they were no longer interested, they decided to retain the unit within SARS.
Yes.
The units that, in terms of the memo, would collect what does it? Intelligence.
Corporate
Yeah,
intelligence.
tactical intelligence.
Yes. Well, and then, but be that as it may, the judges of our country found that there was nothing to suggest that there was such a unit or that it was unlawfully established, and we have to respect that. But that's not, as I explained, that's not the point of this exercise. The point of this exercise is to try and discover whether you and the public protector, in reaching your conclusions, were driven by some dishonest bias or driven by the evidence that is in front of you. Sitting there as we are sitting now, with the evidence that you have seen on this, is there anything that dissuades you from the honest belief that the unit that was indeed established within SARS was unlawful?
No. From the evidence that was before us at the time, no.
Yes.
We
And
still haven't received any evidence to that, to the other effect.
to the contrary, yes.
Yes.
And if the rogue unit or the alleged rogue unit then existed unlawfully and to the knowledge of Mr. Godan, would it then be fair or correct to then say you and the public protector reached that similar conclusion with all the other reports, not from the evidence, but from some nefarious vendetta against Mr. Godan?
No, it would be incorrect. The reports we saw, we considered them. We also had evidence, so supporting evidence submitted by SARS,
Yes.
which will be your memos, etc. That was all taken into consideration to come to a conclusion.
Yeah. Then there is another body of evidence. Because of time, we won't be able to go through all of them, but just let's go to paragraph 37 of your statement. You refer there to some of the independent institutions that came to the same conclusion at some stage or another. Put aside that some of them are alleged to have been discredited, whether we've shown that that may not always be the case, but let's just go through the list. You say that although I reiterate that each report was based on its own independent assessment of basically the same evidence, it is difficult to understand the singling out of our report as quote dishonest and or quote biased without giving the same labels, I think, to the following independent institutions which at some stage or another made adverse findings to similar effect as the public protector report, namely that the unit had been unlawfully established and or operated. Such independent institutions included, and I'm just going to read the list of the reports which you may have seen or heard about or whatever, but which exist around this issue. First one was something called the Kanyane report, which was led by an attorney. You were aware of that?
I don't recall the Kanyane panel. They did a lot of work for SARS, so I could have seen a lot of reports.
Yes.
Yeah.
Okay. You don't recall maybe reading it, but reference to it in the documentation?
Yes.
Yes. Okay, we'll refer to it. It's in the bundles here. Yeah. And okay, but you know that Kanyane is an attorney.
Yes, I do.
Right. Okay. And then the Sikakane panel, we've already discussed that. That's 3 independent advocates. I've mentioned their names. You've said you're aware of that.
Yes.
KPMG is a so-called Big 5 audit firm. And then there was a Brasi SC panel of advocates. Were you aware of that opinion?
Yes.
Yes. And that related mostly to the recruitment issue, or that Mr. van Lochenberg needed to be charged or whatever. It's part of the bundle here.
Okay.
And then the Kroon panel, we've discussed that. You are aware of that?
Yes.
Again, you may not have read it in detail. Yeah. Okay. And then the Office of the Inspector General for Intelligence, will come to that one, but you are aware that there was such a report?
Yes.
Okay. And then the National Prosecuting Authority, there's a document which we already showed here, and I think Honorable Heron commented on it previously when we had Mr. van Lochenberg. But the National Prosecuting Authority, in the hand of an advocate, Pretoria SC, well, you might not know about the advocate, but the NPA had found enough evidence to charge some of the role players, correct?
Yes, I was aware of.
You are aware of that, okay. And then, of course, there's the Sunday Times newspaper, which would say was the largest South African newspaper. Once again, it's alleged that they changed their story, but at some stage they had also found that this was unlawful or suggested that, correct?
Yes, that's correct.
Yeah. Now, before we go to the fundamentals, which is the allegations of dishonesty and bias, I want us to deal briefly with the IGI report, okay?
Okay.
This report, I think it's common cause now, and we have in our bundle, Chairperson, the declassified version of that report. I'll come just now to the controversy about what it's the process of its declassification. But insofar as it has now been declassified, are you aware that it also made adverse findings against Mr. Kodan, Mr. van Lochenberg, Mr. Pillay, and others?
Yes, I'm aware now.
And are you also aware that it suggested that they should be criminally charged for this?
Yes, I'm aware.
And are you aware that that some of them, including Mr. van Lochenberg and Mr. Pillay, were indeed charged
Yes, I'm aware.
at some stage. Okay. All right. Now, the most important thing that I want to establish, which will assist this committee, is the two things. Firstly, it is alleged that the reason why the public protector was called dishonest by the judges, which then leads us to this committee. Because, as I said to you, if indeed the public protector is dishonest and biased and targeting people and so on, then of course she would not deserve to be a public protector. But in this particular report, the reason why it was suggested was because it was claimed, or it was said, the judges said that the public protector had said in her report that she had not seen the intelligence report, and yet she refers to it. Do you get the accusation at least?
Yes, I do.
Yeah. In other words, here's somebody who says, I never saw this report. And says it in the report. In fact, they say she said it explicitly. And then the same person in the report says that this is what the report was suggesting and so on. So that would obviously be, well, it could either be a big mistake, but most probably it would be a dishonest act, correct?
Yes, that's correct.
Yeah. Now, seeing that this is an inquiry, and assuming that we do not have to just swallow everything that just because it happens to be in a judgment and contrary to popular belief, let's now then interrogate that theory. Let's first look at it from the judgment. Can you go to page 4053, that judgment that we had before. Again, going back to the issue of legal, while she's looking for it, of legal reasoning, you would accept, I'm sure any right-minded person would accept, that if there's a finding of dishonesty or anything, but the factual foundation of that finding is incorrect, then obviously that finding cannot stand, correct?
Yes, that's correct.
Yeah. Now, both, well, not both, the judges, the evidence leaders, and Mr. van Lochenberg have told the committee that the public protector said that in her report that she never saw the report, the IGI report. And the evidence leaders in particular, but that is something we're going to argue later, have not even considered the fact that this was an incorrect premise. And the evidence leaders are supposed to be not taking sides, but just assisting the committee. But that's an issue for another day. This is what it says at 112 of the judgment, Chair. 112 refers to the IGI report in general, okay? But let's go to 113 in particular. The judges, including Judge Bako, who was a former public protector, says this. Says the public protector relies on this report, that's the IGI report, despite explicitly stating that she has not seen the report. You see that?
Yes, I do.
Did the public protector in the report that you have seen ever say that, whether explicitly or otherwise, that she has not seen the report?
No.
Could the public protector, knowing what you know about the history of this, could she conceivably have made such a claim? And if she did, could she validly make such a claim?
In the report?
Anywhere, in the report or to this committee or in the newspapers, whatever. Could she say, I've never seen this report on the facts that you know?
No.
All right. Now she's accused of having said that, not once, but many times. And against that accusation, which is not true, then she's found to be dishonest. Let's go to 115. Then they say, despite the fact that the public protector, according to the report, has never seen nor verified the contents of the findings of the OIGI, she ordered Minister of State Security to implement within 90 days and so on. It's the same point. You accept that she never said she didn't see the report? No?
Yes, she
Okay.
did not.
Let's go to 116. Then they say, it is difficult to understand on what basis these sections of the Constitution can notionally grant the public protector the power to rely on a report that she herself has not seen, because this is what she says in the report. We now know that that is not true, correct?
Yes, that's correct. If only they had mentioned whereabout in the report that is captured.
Yeah, well, they were not going to say that because it doesn't exist. But then let's go to 117. Oh no, let's go to 118. We'll come back to 117. Most alarming, however, and despite the fact that the public protector stated in the report that she did not have sight of the OIGI report before coming to her findings, and then it goes on. So that's just another example, correct?
Yes, that's an example.
Yeah. And then the punchline of all this then comes to what brings us here to Cape Town today. At 120 says, this turn of events, in other words, this claims, allegedly false claims by the public protector, is disturbing to say the least, and it is difficult to label the public protector's conduct in this regard as anything but dishonest. So that's the
Sorry,
real.
Mr. Kofo, I don't see.
Oh, sorry,
that on the
120,
screen.
120.
Okay.
Okay, can I read it again? It's a short sentence. This turn of events is disturbing to say the least, and it is difficult to label the public protector's conduct in this regard as anything but dishonest. That's what it says. You see that?
Yes, I do.
Yes. Now, and then it goes on, and then it finds that the public protector was therefore dishonest. Now, according to the peddlers of the theory that the judgments must be taken at face value, even on something like that, when we know that it's just completely false and untrue, the committee's hands are tied. They must just impeach her because it's typed in a judgment. But anyway, so let's now come back to reality and away from the world of fantasy. You were aware that, no, let me do it like this, sorry. You are aware of correspondence between, okay, let's take it step by step. You are aware that the report had been dropped anonymously at the offices of the public protector.
Yes.
Yes. You were aware that there were efforts, and I won't get into much detail because the committee has been played recordings and all that. There were efforts to have the report declassified and subpoenaed from the minister.
Yes, I was aware of those.
You are aware that there was a specific meeting held sometime in January 2019 with the Inspector General, Dr. Dean Twe, to try and achieve that same result.
Yes, I was aware, although I might not be sure about the date,
Yes.
but yeah.
And the reason I'm using the word aware is because, okay, let me put it as a question. Did you yourself have access or read the IGI report?
No.
Why was that? If you were the investigator on the ground?
I did not have top secret clearance, security clearance.
Right. But while you did not have top security clearance, you were aware that some of the people who had such clearance, such as the public protector, had access to that report, correct?
Yes, that is correct.
Right. Now, it's also common cause, I think, that at some stage the report was even published in a magazine called Noseweek. Were you
Yes.
aware of that?
Yes, I was aware. I saw the article in that case.
Yes. Now, so Chair. So I have to consult my notes. Right. And so if the public protector then was, or rather, at least if it was known between the public protector, the minister, the inspector general, that the public protector had a copy of the report, could she have then turned around 5 months later in the report and say she has never seen the report?
Okay.
Sorry.
Just a pause.
Yes, yes.
I'm not sure on
Advocate
what
Bauer?
ba- I'm not sure on what basis this witness would have knowledge about what of that. I mean, about
But
what, about who knew what and what the public protector could or could not have done.
okay. All right. Let me. I think the witness has said that she was aware that the public protector had seen the report. and she was aware that there was some fight. Sorry, let me not call it a fight. There were efforts to classify, declassify, including the recording that was played here in the first week or so, Chair. And all I'm asking her really is that, armed with that knowledge, maybe this is how I should phrase the question. Armed with that knowledge of all these activities that had happened, if the public protector 5 months later had said, I've never seen the report, would you have accepted that as an honest statement?
No, it would not have been honest.
Yes. And so let's go to 5803 of that same bundle A. It's a letter from Dr. Dintwe to the public protector.
Yeah, I think in the afternoon, SEP was much quicker.
I think it's still a morning. Okay, then it might be the wrong bundle.
Just repeat it again.
No,
I was impressed, so it looks like nothing.
No, it's not her fault. It's probably my identification. Yeah. It's the letter from Dr. Dintwe. This would be, maybe it's the file, it's probably might be bundle H, bundle F, item 190. Sorry. And 5803. So it's me, Chair. It's not, it's the afternoon is with me. All right. I just want, okay, I'll deal with two letters to deal with two issues at the same time, to try and save time. Go to paragraph 4 of that letter. This is a letter, Chairperson, from, it's on a letterhead of Department of Intelligence, addressed to Advocate Mvuyana and signed by Dr. Dintwe. Paragraph 4 says, I further confirm that the investigation was finalized on 31 October 2014, and the report was submitted to the former Minister Mahlobo as required by Section 77F of the Oversight Act. So there, it's confirmation by none other than the DG of Intelligence, or rather, I'm sorry, the Inspector General of Intelligence, that indeed such a report exists and that the investigation was finalized as alleged, correct?
Yes, that's correct.
Now, let's then go to 5810 quickly, which is just further on there. And this is where yes. This one, Chair, is a letter from the minister now to the public protector. Now go to paragraph 2 of that letter. Oh, sorry, let's look at the date first. It's the 20th of February, 2019. This will be 5 months before the report. Okay.
Yes.
Yeah. And the minister says, okay. The minister confirms that during the meeting, the PPSA informed her that a copy of the secret report was purportedly delivered to their offices by unidentified persons, which is therefore patently unlawful. it must be emphasized that the PPSA had not brought the unlawful disclosure of the classified information to the attention of the relevant authorities and so on. And then she complains about other things. And then she says, she refers at paragraph 5 to accordingly, the leak of the report to the media and the publication thereof on Newsweek on 1 February 2019 is prejudicial to the national security interest and so on. So this would mean this was already after the Newsweek article as well, right?
Yes.
And then let's just quickly run to paragraph 11. She says, yeah, it is advised that the PPSA employs the following security measures. The report must be handled in accordance with the standards prescribed in the MISS. The report, as well as the copies thereof, must be surrendered to the minister, and so on and so on. The identities of all persons who had access or sight to the report at the office must be furnished, and so on. Now, don't worry about so much about the contents of all those and the complaints here. The point I'm making is, was it ever suggested by the public protector as early as 20th February 2019 that she did not have the copy or had not seen it or had not read it? If you just look at paragraph 2 of that letter, where it says the minister confirms during that PPSA informed her that a copy of the report was delivered.
Yes. Oh, but then you're saying I mustn't take notice of what is said underneath.
Yes. No, I'm just
before
confining,
20th
I'm sorry,
February.
ma'am. I'm
Sorry.
just confining my question to the allegation that the public protector said she had never seen the report, whether that can be, that is supported by what I've just read out to you.
No, she informed them in the meeting from what this letter is saying.
Right. Now, and yet the judges made a finding of dishonesty against her based on some allegation that she said in the report that she never saw it. I invited Mr. van Lochenberg here to show us where the public protector says that in the report, because he had also used the same words as the judges. He said she had emphatically denied having seen the report. And I don't think he ever considered the point, but it became obvious that this was nowhere in the report. From your knowledge of the report, is there anything that says that the public protector claimed not to have seen the report which should attract this finding of dishonesty?
No. After Mr. van Lochenberg stated that, we went back to check. We didn't find any paragraph, sentence stating that the PP had never seen the report.
Yes. Right. Now, that's, Ms. Mvuyana, is the real purpose of this exercise called an inquiry. It is to inquire onto those things. And we either do that or we just take it at face value, and in which case we should not waste the time of the taxpayers. Anyway, now let's then go to the issue of bias you've already dealt with. The two issues really that the public protector is accused of in relation to the so-called rogue unit report is this dishonesty, which we have now established was baseless. And then the other one is the bias that we spoke about earlier in the morning. Namely that there was some vendetta against Mr. Kodan, and you were all dreaming up all these things about the establishment of the unit and procurement of equipment. Let's deal very quickly with the question of equipment. There's a theory that, again, in the pursuit of your conspiracy and vendettas, you made up the existence of spying equipment, which is actually not existent. And in fact, I think Mr. van Lochenberg said that equipment is, you can buy it from Macro or Game or something like that. Now, you were involved in this investigation. Just tell the committee about the story of the equipment. What equipment was referred to, what kind of equipment it was, and where is it now?
Okay, I'd have to also go back to the report there to refresh my memory.
Yeah.
It was a long list of
Yes.
equipment.
Sorry.
So I won't remember the specifics. But they were a list. When we requested the information from SARS, we were provided with the information. We also looked into, like I stated before, the 2014 matter, which was finalized in 2017. The file did have also lists of equipments that had been purchased. This is from the complainant in that case. We also had memorandums requesting deviations to procure or to appoint service providers that would then procure what was termed security equipment for the unit. I'll just pause to say that the unit, some call it the rogue unit, it changed the names a couple of times during the years. So it might confuse the reader which unit is being referred to. But we established that it's the same unit that does the same thing, just that it changes names. So those service providers were appointed. The equipment was delivered and used by the operators or employees of the unit. That would be an example, would be your night vision binoculars, which Mr. van Lochenberg, I think, claimed was used for border security or customs. There were also listening devices. Another document even specified and showed pictures of the equipment. It is in the report, but like I say, I can't refer to the specific paragraphs now. So that was the evidence that we had before us. The denial of the equipment, unfortunately, I can't comment on because it's his word. But when, after the investigation was completed, we were then invited by SARS to come and view or the handover of the equipment. They were moving buildings, so they needed to, we needed to be there. It was an invite as well for us that, okay, the equipment is going to be moved. So, and public protector, you're invited to come and verify and also be a witness to such movement of the equipment. We then went there. I won't mention where. There was equipment. We verified the list of the equipments that were in the report with some of the equipments that were present in that particular building. We ticked what we could find and noted what could not be located. Unfortunately, the officials that were there, we couldn't then restart the process of investigation and interviewed them in terms of what was it for. But the labels of the covers of this particular equipment, you could see what they are for, and they were moved. The verification list was sent to Mr. Matabuche. So currently, I'm not aware where it is, but it's in the possession of SARS.
Yes. Okay. Just so that we get out of this equipment story quickly. I'm going to try and use two dimensions. Am I right that as far as the equipment is concerned, there were two issues? One was whether it is buying equipment, but the other one was how it was procured, whether it's buying equipment or not, but it had to do with its procurement, correct?
Correct.
Right. Now, what was your finding on the procurement of the information? Assume for now it was just, equipment for playing or pretending cops and robbers here, and there was nothing dangerous about it. What was your finding regarding its procurement?
Our finding was that the procurement legislation hadn't been adhered to. So what we noticed there is that when there was a request to deviate from normal procurement processes, one of our reasons then for finding that procurement legislation wasn't adhered to is because the reasoning given for the deviation, which in this case was allegedly, I might be mistaken, an emergency. So that is National Treasury Regulation 16A6.4, which they used in this instance. That was the basis of our finding then, that there was no emergency in this instance. And from the evidence that was submitted, it couldn't be proved that an emergency existed for the purchasing of that particular equipment.
Right. Okay. So once again, we'll come to the nature of the equipment and whether it was spying equipment or whatever. But your finding was that whatever it was irregularly procured.
Yes.
Okay. And your adverse finding in that regard dealt with, okay, if you go back to the letter, back to the 7-9 letter at page 6272. We're not doing the pages. At paragraph 14.2.8.
Are you asking, sir?
14.2.8 of the letter that we were dealing with earlier.
Paragraph 14.2.8.
14.2.8, yeah. I think our pages were not aligned, so that's why I'm just using the paragraph.
The long letter.
Oh, no. Yes, the 66-page letter.
You had it before, so we know about it. Just go to your shelves. (14.2.8).
Yeah. I think it was bundle on your version, it was bundle A6472 or something. Okay, please keep that because we're going to keep on coming back to it. Right. So I was just going to ask you about the estimated cost of the equipment that you're saying was irregularly procured. 14.2.8 refers to a figure of 40 million, which was still within the contract amount and so on. Was that the value or the estimated value of the equipment?
This is what the memo stated.
Sorry, the memo which was requisitioning the equipment.
Yes, so
Okay.
the contract amount was for the estimated value of 40 million.
Right.
Yeah, I won't be able to comment on the equipment that I saw if it's worth 40 million.
Yeah, no.
But it
Oh,
also includes a variety of services besides only buying equipment.
yeah, okay. And go to the 14.2.22. There's a list of equipment there. And okay, I don't know these things, but I'll just highlight those that look like spying equipment to me.
I'm sure you know a detector. There's something called detector there.
I do. So we'll just take a random number 1, 2, 3, 4, 5. It's a basic course in electronic eavesdropping. That's part of the manual, I suppose, or something that was part of the list, correct?
Yes, or it's or they actually went through a course.
Yes.
Yes.
And then there's a famous one there in the next page. On to advanced course in electronic detection. That's the one, even the chair knows that one. Even though he's not James Bond 007. And then basic course in electronic eavesdropping. You see that?
Yes, I do.
Then let's just go further down. TGVCAL J56 signal jammer. You know.
Yes,
Right.
I've seen the list.
That one. Yes. No, I'm just doing it for the record. Yeah.
Okay.
And the other one, Signet Advanced Counter Surveillance RF Detector. See that?
Yes, I do.
Go further down, Cellular Detector Surveillance Countermeasure, whatever, Winkelmann with SA9118, whatever that means.
Yes.
Anyway, these were some of these, I've not read all of them, obviously, were some of these the kinds of equipment that featured in the list that you say you later went to verify physically?
Yes, they were.
Yeah. And all this information that were the 40 million, this list and all that was then contained in your 66-page letter, which was similar to the one sent to Mr. Kodan, correct?
Yes, I believe so.
In other words, you were now saying to them, this is what we have. This is what we have found in our investigation. Please, this is your opportunity to refute it. And therefore these will be our final conclusions, correct?
Yes, that's correct.
Yeah. Then at 14, just go further down, 14.2.24. Yes, there you talk about, remember I said there are 2 dimensions. There's the rogueness in terms of the spying equipment, but there's also the PFMA, alleged PFMA non-compliance.
Yes.
So you then spell out to them what Section 38, which we all know, of the PFMA provides, says that the accounting officer for a department, in this case, that would be Mr. Kodan, trading entity or constitutional institution must ensure that the department trading entity constitutional institution has and maintains effective and efficient and transparent systems of financial and risk management, internal control, an appropriate procurement and provisioning system which is fair, equitable, transparent, competitive, and cost effective. Did you find that these things were procured by such a system?
No, we found that they were not.
Yes. Okay, and then the highlighted parts include, if you go further on, Tsepo, preventing unauthorized and irregular, fruitless, wasteful expenditure and losses resulting from criminal conduct. On discovery of any unauthorized, irregular, fruitless, wasteful, must immediately report and take effective, appropriate disciplinary steps and so on. Were such steps taken regarding this irregular expenditure?
No. Prevent unauthorized, irregular, and fruitless and wasteful expenditure and losses resulting from criminal conduct.
And
Is
then
that the
G is
section?
important, on discovery of such to report it in writing.
Yes.
Was it done?
No evidence was submitted
Yes.
in regards to this.
Okay.
The 7-9 was also served on SARS, so they also did not respond.
Good. Okay, that's important information. So the 7-9 was served on SARS, Mr. Kodan and Mr. Pillay.
Yes.
So each one of them, if there was evidence to refute these allocations, they would have come back and given you such authorization or reporting in writing or whatever.
Yes.
And was any of that given to you?
No.
Right. Okay, then let's jump to 14.2.28, just so that we can wrap up the equipment issue. Can you confirm this is what the public protector and you, as the drafter, said then in relation to this issue? 14, yeah. SARS failed to provide me with documents relating to the procurement of the equipment for the CBU, NRG, and subsequent SPU. Those are the various names of the rogue unit that were used from time to time. Such conduct is in violation of section 181.4 of the Constitution. And then 14.2.29, it is extremely unlikely that a unit carrying out investigations on behalf of SARS would not procure equipment necessary for the fulfillment of these duties and functions. 14.2.30, it is unclear why SARS and or its former employees would keep procurement of equipment such a guarded secret. Without proper explanation, I can only infer the proper procurement processes were not adhered to. And then the next one says the existence of the unit is an indisputable fact, and therefore the buying of equipment is an obvious after effect. I am of the view that the failure and blatant refusal of SARS and its former employees to provide me with records of the procurement and whereabouts of the said equipment is unwarranted and undermines my ability to perform my constitutional functions. Whether in the circumstances that you have described, were those conclusions justified?
Yes. The information, once the section 7.9 was issued, they could have come back and disputed these findings and provided the necessary evidence. However, they did not. So we proceeded to make adverse findings.
Yes. In the absence of any countervailing evidence being supplied to you, did you have any choice but to make adverse findings?
No, the evidence is clear. We've already portrayed the evidence that we received and explained the evidence that we received. We explained the list. I see on this document, it hadn't been blacked out. That is good. That means Mr. Pillay knew what equipment we had or had been made aware of. So there was no other way to not come to this kind of conclusion.
Yes. And let's go to 14.3.43, please, Tsapo. Oh, I'm sorry. This, just so that I don't confuse the record. This now, Chair, refers to not so much to the equipment issue, but to the issue of recruitment of personnel. That's the heading at 14.3. And I'll try and move on this one quickly. Is it correct? What were your findings? Can you just tell the committee briefly, what were your findings in this respect of the regularity or otherwise of the recruitment of the members of the unit?
If I recall correctly, there was no recruitment process followed in this instance. Yeah, posts were not advertised. There was headhunting, but the headhunting was not formalized. There wasn't even, I believe there wasn't even a policy on how employees would be appointed and what expertise. So the finding then was therefore that recruitment procedures had not been followed.
Yes. And specifically, if you go to 14.3.4.2, Chair. No, let's start, start at 14.3.4.1. There's a memorandum that's referred to there, and I just want to highlight a section which deals with what you've just told us now. Yes, just after process. Background, go down to aim and then process. Okay, aim, it says that the aim of this submission, this was made by Mr. Jean Ravel and Pillay, or rather Mr. Sipombonga to Mrs. Jean Ravel and Mr. Pillay. The aim of this submission is to obtain approval for the appointment of personnel referred to below. These are external candidates, okay? And then under process, the second paragraph, Chair. While posts were not advertised in the conventional manner, individuals identified as having the necessary competencies for the unit to operate were asked to submit their CVs to a panel for interviewing. Such individuals are recruited from both SARS and the relevant security sectors and have the following range of skills: intelligence, legal, accountants, and investigative skills. So that's the type of person we're talking about, correct?
Yes.
Okay, now let's go to 14.3.4.2. There's a list of some of the people who were employed by the unit in this irregular fashion, okay? Just a cross section again, Chair. Yeah, Mr. Timo, oh, sorry, maybe let me not call the people's names just to protect them. Okay, one person, Chair, I'll just read the qualifications and experience here. Person number one, it says intelligence officer and forensic investigator at Defense Intelligence, right?
Yes.
Person number two, formerly employed by the South African Secret Service. Okay. Person number three, directing staff at School of Intelligence, Defense Force. Person number four, experienced investigator, commercial field employed by SARS. Then the others have other skills like forensic investigator, senior auditor, and forensic auditor. But the first four were clearly intelligence, serious intelligence background, correct?
Yes, that's correct.
Right. And then 14.3.4.3, this is then the relevance to Mr. Kodan. It says this memorandum, which dealt with all these things, was approved by Mr. Kodan on 11 November 2002, in which he noted that such approval was, quote, subject to a discussion with Ivan, that would be Mr. Pillay, et al. On role, functioning, and reporting. So that was what you found, that Mr. Godane actually approved the recruitment practices described above, correct?
Yes.
Then can we quickly run to 14.4.3.1? Sorry, 14.4.31. Go back to point 30, 14.4.30. Okay, sorry, it's me. Yeah, 14.4, not 0.3. Okay, this time it's your fault, Sapo. It's that afternoon thing. 30.
30 and then go to 31.
Yeah, the preamble, yes. Okay, now let me just pause to explain where I'm going with this to the chair. Chair, there is what I'm going to try and condense this. One of the red herrings in this evidence is that is this issue that the National Security Intelligence Act does not apply to this whole situation because it's about national security and so on. And our theory, when we argue the case, will be that that's a deflection, because let's assume that act does not apply. But certainly, if that act doesn't apply, let's say this committee decides to intercept my communication. The fact that I might say, no, it's illegal under some act which doesn't apply is irrelevant. The point is that you are not allowed to intercept my interception under some law or another, yeah. Or rather, let me put it in reverse. There's no law authorizing you to intercept my communication. So sorry, I just wanted to accept that, to expect that, to explain that. So in this case, you as the public protector, looking at the cluster of laws in South Africa, had identified that one of the acts that would be breached by the so-called rogue unit is the one referred to at 14.4.30. The preamble of the Interception of Communications and Provisions of Communication-Related Information Act 70 of 2002, shortly called the Interception of Communications Act, describes the purpose of the act as inter alia to regulate the interception of certain communications and the monitoring the provisions of certain communication-related information. And then 14.4.31, section 1 of that act defines intercept. And again, it's too long, I won't read it, I'll just jump. It says, means that the oral and other acquisition of the contents of any communication through the use of by any means, including an interception device, so as to make some or all of the contents of a communication available to a person other than the sender or recipient. And then it lists things like monitoring of any such communication by means of a monitoring device. Remember from our list, we had such monitoring devices. Then viewing, examination, or inspection the contents of any indirect communication, and so on and so on. The long and short of it is that it was your view that the interception by the alleged rogue unit breached this act, correct?
Yes, that's correct.
Yes. And again, at the risk of sounding like a broken record, you are inviting them by this section 7.9 to then refute those conclusions, correct?
Yes, that's correct.
Right. And 14.4.32, Chair, that's the highlight then of this whole thing. It says, in terms of section 3 of the Communications Act, I suppose that act provides that communication may only be intercepted by authorized persons in execution of an interception direction. An interception direction is an authorization issued by a designated judge on application to an applicant. We've already confirmed this earlier, that this act is the one that we might not know its name, but it's the one that says you can only intercept if you have a judge's order, correct?
Yes, that's correct.
Yeah. And then just for the sake of completion and on that name issue, at 14.4.33, that's probably where the confusion comes about Van Rensburg, De Waal, and Lombard. But just to help you to remind yourself on that, it says, the evidence before me indicates that during 2007 until November 2007, Mr. Pillay and Mr. Van Rensburg irregularly recruited Mr. Helgard Lombard and Mr. De Waal and or authorized Lombard and Mr. De Waal to intercept communication within the offices of the DSO and those of the NPA without an interception direction issued by a designated judge in terms of the Regulation of Interception, Communication and Provision Communication Act, I suppose. Was that your finding?
Yes.
So your provisional
Conclusion.
finding?
Yes.
Yes. And unless someone was to bring the direction by a judge, then that provisional finding would become a definite finding.
Yes.
Did anyone ever produce evidence that there was such authorization?
No, they did not. They denied, Mr. Pillay specifically denied authorizing Mr. Lombard and De Waal.
Right.
Okay, can you pause there for 10 minutes?
Yes, Chair. Yes.
Just
yes,
go for
yes.
10 minutes and
That's
back at 15:46. Thank you.
Thank you.
Recording stopped.
Okay, we're back, colleagues. We resume with Advocate Mpofu and Ms. Mvuyana.
Thank you, Chair. I just wanted to round off. There's an issue which another red herring issue bandied about by those who want to, I think, distract us from the real issues. And this has to do with Mr. Pillay specifically. Unfortunately, Mr. Pillay is also being shielded from coming to finish his cross-examination. Apparently, since he was not available last year, he's not available for the rest of his life. Even though he, the one who volunteered to make a public submission. But be that as it may, Mr. Pillay, you'll remember that one of the issues that you, which I would have loved to question him on, or I will question him on if he ever comes back, was this issue about his qualifications, correct?
Yes, yes.
Now, this whole thing is just distracted into some issue about a nonsensical issue about a matric certificate and so on. But the point really, if we go back to, are we still at the letter, Tsepo? '79 letter, yeah. Sorry, we're going backwards this time. At 3.10, yes. 3.10, the allegation from Mr. Shivambu or from the complainant was that it had nothing to do with matric or anything at this stage. It says Mr. Pillay was appointed to the position of Deputy SARS Commissioner and subsequently as SARS Commissioner, whilst he did not possess the necessary qualifications for the position, right?
Yes.
Positions, sorry. And you at 8.6, again, when I say you, I mean you and the public protector, then decided that one of the issues you are going to deal with in phase 1 is that issue, and you phrase it like that. The allegation that Mr. Pillay was appointed to the position of Deputy SARS Commissioner and subsequently SARS Commissioner while he did not possess the necessary qualification for the position, correct?
Correct.
Yeah. And then if you go to, sorry, go to now 14.5.4. This is, bearing in mind now, this letter is actually to Mr. Pillay. So again, he's being given an opportunity to refute this, that he did not have the necessary qualifications. And while we are going there, let me just say that Mr. Pillay seems to be the elusive Mr. Pillay who doesn't want to come back here. Seems to be a unique species in South Africa. Firstly, he got a retirement, which was not a retirement, and got paid a taxpayer's account. You were not involved in that particular investigation of the Pillay pension scandal, correct?
Yes, that's correct.
But now here again, he hits another first. I think he must be the first person or the only person, even in the future, to be a SARS commissioner armed only with a matric, if that. But anyway, the point is that at 14.5.4, you say that SARS in their response dated did not dispute that Mr. Pillay did not have a degree and that he possessed a matric certificate. So even on the version that you sent to him, you were assuming for the purposes of argument that he did not have a degree, but possessed a matric certificate. You see that?
Yes.
Yes. Now, somewhere in the report, and the public protector will deal with this when she gives evidence. For now, let's assume that it's some mistake. But somewhere in the report, it's suggested that he does not have a matric certificate. And then everything else is now pinned on that mistake. To distract us from the fact that even if he had a matric, he would not qualify for, yes. To distract us from the fact that even if he had a matric, really a matric certificate cannot be qualification to become the commissioner of SARS or even the deputy. And at 14.5.8, sorry.
I don't want to interrupt you, but would it assist you if I told you where the reference was?
Of the
Matric.
yeah, yes, it would assist me. It's page 98.
It's paragraph
5.6.26. Yes, I've got that. Yes, thank you. What's the fuller reference?
I think it's 3.13 para 5.6.26.
Yes, can you go there? It's a purchase. Thank you. Just for completion. Okay, while she's looking, then I'll use this to address the chair on this. Chair, this reference is, we did deal with this briefly with Mr. Pillay, though we didn't complete it. It's about this, the issue of whether or not Mr. Pillay was being favored by Mr. Godan because of their history in the struggle and all that. And we will argue at the end that even the most heroic experts in the struggle cannot give you qualifications to be the commissioner of SARS armed with a matric. Otherwise, the many people who were involved in the struggle and they're working in places where they're qualified. Are you finding it, Sapa? Yeah, it's in the report which we referred to earlier. Okay, actually it's fine. We can do without it. Okay, you've got it. 5.6.26. Yeah, thank you. Yeah. Yes. Now, here, Chair, is, as I say, for now, until the public protector comes, we'll put this in context. Let's assume that this was a faux pas or a misprint or a mistake or whatever. But this is what now is being latched on. It says, SARS and Mr. Godan considered that Mr. Pillay did not possess a degree, qualification, nor a matric certificate. Now, we know that Mr. Godan considered, both Mr. Godan and Mr. Pillay did concede that he did not have a degree, correct? Your mic is not on.
Sorry about that. It was switched off when Advocate Baba was speaking.
Okay.
No, I was just saying that, yes, it's correct that they did concede that he did not have a degree. I was just stating that SARS in their response stated that there was no formal qualification.
And, okay, good.
Yeah.
And I think that's, okay, we'll get to that. All right, I didn't know that you know that. That's the part that I was going to say. I was saying it was going to be explained by the public
By the
protector.
PP.
Yes,
Sorry.
but okay, no, that's good. It's even better if it's explained by both of you. So the SARS considered that he had no formal qualification, correct?
Yes, that's correct.
And that would include the matric or anything.
From my assessment, yes.
Yes. But so the mistake in that sentence would be to ascribe that concession to Mr. Godan, because in fairness, Mr. Godan only considered that he did not have tertiary education. I think that's what the words he used. Take it from me.
Okay.
Correct?
Okay, correct.
Yeah. And Mr. Pillay himself also could not be accused of making that second concession. He considered that he did not have a degree, but he claimed that he had a matric. That, at least he said that to the public protector. That's now common cause.
Okay.
Right, okay. So the point I want to make here is that instead of running with this matric thing, which as I say is a red herring, all these people, SARS, Mr. Godan, Mr. Pillay, Mr. XYZ, everyone alive in South Africa accepts that the Mr. Pillay did not possess a degree, okay?
Correct.
Yes. Now, when you asked SARS for, or anybody, let me put it this way, have you ever seen a matric certificate of Mr. Pillay?
No, I have not.
Yes. And when he comes back here, if he ever dares to come back, we will ask him to bring that matric certificate. But until then, we'll assume that he does have that certificate. Okay?
Okay, noted.
Right. Now, so the point I simply want to make is that that whole matric thing just was used as a distraction. The gist of what you were investigating is what is stated, which I read to you at 3.10 and 8.6, namely that Mr. Pillay was given those positions without a suitable qualification.
That's correct, yes.
Yes. And if it's framed like that and not use this red herring story of the matric, was that allegation substantiated?
Yes, from the evidence that we had before, it was substantiated.
Yes. And we know that there was some mumbo jumbo that was given as the reasons for that. One of them was something called strategic fit or goodness of fit or whatever.
Yes.
Some method that makes you to overlook people's lack of education.
Yes, goodness of fit.
Yes. And then the other one was struggle credentials. That's the Mr. Godan said Mr. Pillay deserved that position despite not having any formal education, or I'm sorry, or any formal qualification according to SARS, or any tertiary education according to Mr. Godan, because he had made a good contribution to the struggle. Is that correct?
Yes, in not so many words, but yeah, he also said he was a long-serving member of the public service.
Yes,
Mm.
yes, true. And yeah, it contributed to the transformation of SARS and that kind
Yes.
of thing. Yeah. Okay. All right. So the reality is that we had somebody who at best for him was qualified with a matric certificate from 1970 at some place, and which is indistinct in Benoni somewhere. Or we had someone who had no formal qualification, at least that could be proved by SARS, being the commissioner of SARS of South Africa.
Yes, that's correct.
Yeah. And the court found that this was that the public protector was disingenuous because of that mistake, of that suggestion of conflating SARS with Mr. Godan, that said that he did not have a matric certificate, correct?
I'm sure, is that what the court said?
Well, I'm shocked too. Yes, that's what
Okay.
the court said. The court said, sorry. Sorry, just trying to find it. Chair, I'll find it just now. And maybe let me ask my. Yeah. Well, I'll come back to it, Chair, to the reference, yes. But yeah, I'm just paraphrasing what the court said effectively, that, or rather it went on this issue of the matric certificate and the fact that Mr. Pillay had told the public protector in a meeting that he had a matric certificate. So how could she put that sentence that we put up there, and therefore she was disingenuous and so on and so on.
Okay, noted.
Right. And well, that went up. It's not just this court, to be fair to the court of Mr. Bakwa, of Judge Bakwa, that went up to the Supreme Court of Appeal, and they rejected any attempt to appeal, and it went to the Constitutional Court. They also found nothing wrong with the judgment, or at least there were no prospects of success, according to those courts, without any. So it's 3, 5, 11, about 19 judges or 20 judges who endorsed that view. But and in fact, what was said is that you and the public protector and other people were deserving of censure, punitive costs and personal costs for even daring to suggest that Mr. Pillay, among other things, Mr. Pillay could possibly not have been the right person with his credentials or lack thereof, educationally speaking, of heading our revenue services. All right, then we go to yeah, this letter of yours is too long. At least we're now around page 63, Chairperson. You'll be happy to know of the 66 page letter. I think we've covered this issue about you saying it's 16.2. Regarding whether SARS failed to follow correct procurement processes in the procurement of intelligence equipment, which the intelligence units utilize for gathering intelligence, and if so, whether such conduct amounts to maladministration. You found that that is established. We've already covered that, correct?
Yes, that's correct.
In 16.2.1, the allegation that SARS failed to follow the proper procurement processes in the procurement of intelligence equipment with the intelligence unit utilized for gathering intelligence is substantiated. Okay, we've covered that. Then the next one is 16.3, regarding whether SARS failed to follow proper recruitment processes in the appointment of employees who work for the intelligence unit. We also covered that. Yeah, that was also substantiated, correct?
Yes, it was.
But notably, 16.3.5, which we would like to highlight for the committee. It says the apparent denial of Mr. Gordhan of any involvement in participation in the recruitment process of one or more of the unit's employees is improbable. The Sikakane report and the Jean Revele dossier confirm that Mr. Gordhan played a role in the recruitment of Mr. van Lochenberg. Remember that?
Yes, I do.
And you presented this to them for refutation, correct?
Yes.
And then 16.3.6, you say, I've also noted that Mr. Mahashula's denial of the existence of the unit and recruitment of employees thereof is a misrepresentation. Mr. Mahashula, at the time, the members of the unit were transferred within SARS to form CBU, and the appointment of external staff was the Chief Operations Officer, Corporate Services. He approved the memorandum submitted by Mr. Pillay relating to employees to the newly formed unit. So you give the basis for disbelieving Mr. Mahashula, correct?
Yes, that's correct.
And then the punchline is 16.3.8, which I'll read to the record. It says the conduct of Mr. Gordhan and Mr. Pillay in approving the memo for the establishment and invariable recruitment of staff for the intelligence unit in the manner described is improper, and thus amounted to improper conduct as envisaged in section 182.1 of the Constitution, and maladministration as envisaged in section 6.4 Roman 1 of the Public Protector Act. That was the concrete finding, correct?
Yes.
Then regarding whether the intelligence, 16.4, regarding whether the intelligence unit carried out irregular and unlawful intelligence operation, and if so, whether such conduct constitutes maladministration. That is that whole debate about whether it amounts to interception and Mr. Duval and what have you. You found that that was substantiated as well, correct?
Yes, that's correct.
Then finally, at 16.5, it says regarding whether Mr. Pillay was appointed to the position of Deputy SARS Commissioner and subsequently as SARS Commissioner whilst he did not possess the necessary qualifications for the position, and if so, whether such conduct amounts to maladministration. Again, there's no mention of matric here or anything. It's simply whether he did not possess the necessary qualifications for the positions, correct?
Yes, that's correct.
And then 16.5.1, you say the allegation that Mr. Pillay was appointed in the position of Deputy SARS Commissioner and subsequently the SARS Commissioner while he did not possess the necessary qualifications is substantiated, correct?
Yes, that's correct.
Yeah. Oh, I'm sorry, Chair. The part that you said you were shocked by, and I said I shared your shock, is to be found in the judgment at paragraph 227. Oh, sorry, Tepa. It's page 4093 of that bundle of judgments. This is what our judges said. Bundle C, yes, I'm told.
Paragraph.
It starts at 227, but I want to read 229. I think that's a special one. Okay, the judge says, firstly, there's no requirement. I'll read it, Chair. We'll catch up with it. There's no requirement that only the holder of a degree can be appointed as Deputy Commissioner of SARS or hold an acting appointment as a commissioner. Secondly, there's no rational basis for the conclusion as Mr. Pilay's qualification for appointment as Deputy Commissioner were clearly taken into account, and it was found that he was suitably qualified for the appointment. What the public protector presumably meant by her statement is that the fact that Mr. Pillay does not possess a degree was not taken into consideration. But in as much as the possession of a degree is not a precondition for the appointment as Deputy Commissioner, the public protector's reasoning is fallacious. 229. And then it says from 233. No, sorry, let's start at 232. This is the revolutionary consideration. It says there are three difficulties, whatever. Firstly, it is doubtful that SARS would have stated that Mr. Pillay did not matriculate, as that would have been a false statement, says the judges. As Mr. Pillay matriculated in 1970, having completed his secondary school studies at Merebank High School, did you ever get such information, such proof of that?
No, we didn't even have his CV because SARS couldn't find
Yeah.
the CV.
And then the judge says, secondly, nowhere in Minister Kodan's affidavit is this stated that Mr. Pillay does not possess a matric certificate. That we concede. It was only SARS who said no qualification, correct?
Yes.
And then what Minister Kodan recorded was that quote, Mr. Pillay, like many other South Africans who dedicated their lives to the struggle against apartheid, does not have any tertiary qualification. So this is what I was referring to when I was saying one of the reasons given for employing him in such a sophisticated position was his dedication to the struggle, correct?
Yes, apparently.
Thirdly, the statement are contradictory to the evidence the public protector had in her possession at the time of the release of the report. Did the public protector have such evidence contradictory to the lack of qualification?
We did not have a matric certificate. We did not have his qualifications. So which evidence are they talking about?
I don't know. Then at 233, it says somewhere in the middle there, for no apparent reason, the public protector disregarded his evidence. In fact, she doubled down on this issue by finding that Mr. Pillay possessed neither a tertiary qualification nor matric certificate. And then this is what the public protector says, which is rejected by the judges in explanation, Chair, at paragraph 233. This is what she said in her affidavit. It is denied that the public protector made a malicious slur against Mr. Pillay. The issue of the matric certificate could have simply been resolved by Mr. Pillay providing that information to the public protector when he was asked to give information about his qualifications. He failed to do so, as SARS fails to answer the questions on Mr. Pillay's qualifications. In any event, there's nothing in the report of the public protector to support the contention that she concluded that Mr. Pillay had no matric. And that's the passage that we read earlier, which attributed that to SARS and to Mr. Kotan wrongly in Mr. Kotan's place, but not to the public protector. What the public protector said was that it was not denied by Kotan or SARS that Mr. Pillay did not possess a tertiary education, including matric. So here it was being explained in simple English that the public protector did not say in her report that Mr. Pillay does not have a matric. She simply said Kotan and SARS did not deny that he did not possess a tertiary education, including a matric. You understand the difference between those two things?
Yes, I do.
Congratulations. Okay, then the 234, it says, counsel for the public protector, in addition, submitted during admin that Mr. Pillay, quote, in his long and verbose affidavit dated 14 April 2019, Mr. Pillay does not disclose what his qualifications are, except that he has some experience, which amongst others come to the fact that he was in the struggle for the liberation of South Africa. And then here's the punchline, which brings us here to this room today. The contention in the answering affidavit and submissions made on behalf of the public protector that the public protector made no finding that Mr. Pillay had no matric and that Mr. Pillay did not provide the information about his qualification when he was asked to do so is disingenuous. Say the charges. Was that contention disingenuous? That firstly, that the public protector herself made no finding that Mr. Pillay had no matric. Compared to what I've written, I read to you earlier, do you accept that that is not what she said?
No, I believe it might have been misinterpreted here, but the report states that there was no evidence, if I can summarize, of Mr. Pillay having a formal qualification. So that includes a degree and in argument, a matric.
Yes. And then the second one that is called disingenuous is that Mr. Pillay did not provide the information about his qualification when he was asked to do so. Did he provide any evidence to support his claim of the matric?
No.
And then this is the last part. It says, the conclusion that Mr. Pillay had no degree and no matric was central to the public protector's finding that Mr. Pillay was not qualified to be appointed deputy commissioner. Is that true? If, let's assume for a minute, there had been a matric certificate, would you have concluded differently? Would you have concluded that now that means he's qualified to be commissioner for SARS?
No. Because besides the qualification, the manner in which the SARS went about because even in the report, we first started with the deputy commissioner position and stated that it was a new position and it had to be properly created within the organogram of, if I can use that word, and Mr. Kotan had not done that. So, and in not doing that, that means that the duties were not properly identified, the competencies were not properly identified. When it then came to the appointment to commissioner, SARS claimed to have used the goodness of fit model, which then they said only identified people based on their competencies in relation to leadership and etc. Qualifications was not really a big thing for them, and the experience within SARS, etc. So the finding made by the PP was based on that, and not necessarily the matric. When we quoted the Constitution here, the fact that, yes, he might not have a degree or have enough experience at SARS, but when we looked at other adverts for the position of commissioner, they require a degree now. So to not require a degree, it really didn't sit well, and yeah, we couldn't have made another finding, I believe.
Yes. And then here's the coup de grace. Apart from it being disingenuous, based on all this, what I've just described, it says, accordingly, at the time of the report, the public protector well knew that Mr. Pillay has a matric certificate. Is that factually true?
I was not in the meeting that the judges claim is where the PP learned of Mr. Pillay's matric status,
No.
or if any.
Okay, that's
Yeah.
fine. No, assume that in that meeting, he did claim to have a matric certificate. I'm asking you about this statement. Accordingly, at the time of the record, the public protector well knew that Mr. Pillay has a matric certificate. In other words, she either had seen it or she was convinced of that fact. Is that true, factually?
No, that is incorrect.
And then it says her conclusion in the report that Mr. Pillay does not hold even the basic qualification, notwithstanding the fact that on 25 March she accepted that this was a matter of public record and was within her knowledge, is astounding. Well, apart from that adjective, is what precedes it, that she accepted it, that he has a matric. To your knowledge, is that true?
No, on the 14th of March.
Yeah, well, yeah, I
know.
accept that you didn't know the date, and I mean,
Yeah, no, but no, I did not.
Yeah. And then it says, we submit that this further demonstrates that the public protector closed her mind and adopted a process of irrational reasoning. I rest my case. So that's the kind of thing that this committee is supposed to inquire into and make up its own mind. And it will have to find, I suppose the public protector is going to testify for herself, whether A, she has ever seen such a matric certificate, B, whether she ever accepted that it exists, and C, even if it existed, whether that would be sufficient qualification to be commissioner for SARS. Then it comes to the conclusion, and Chair, I know this letter, we've now come to the page 64 to 66. And then I want to just read the gist of it, and it would be the same. The one to SARS, Mr. Godan, would also be the same. Say, I hereby afford you 17.1, sorry. I hereby afford you, Mr. Pillay, the opportunity to comment under oath to the above terms of this notice, the 65 pages. You are requested to respond to the above as within 10 working days as per 24D. I also invite you to state under oath that you have declared or provided to my office all relevant information, documents, any other evidence relevant to this complaint. You may engage with the public protector investigation team through the chief investigator, good governance, and so on, or forward all the inquiries to Mr. Kabinde, that was the public protector's personal assistant, correct?
Yes, that's correct.
Should you be in agreement with the intended findings, it will be necessary to issue a report that simply indicates SARS' intention to remedy the maladministration and improper conduct referred to in the report. However, should you have evidence contradicting the evidence in my possession relating to this matter, kindly forward same to my office. Please take note that the appropriate remedial actions will only be taken once an investigation is completed, having taken into account your response, if any, to my preliminary findings herein. Should you fail to respond or contradict or rebut my preliminary findings, my investigation will be finalized and remedial action taken in terms of 182(1)(c) of the Constitution, and my report will therefore be published in terms of Section 1 of the Public Protector Act. Further, take notice that in terms of Section 7(2), the contents of this notice are confidential and no person may disclose them without my authorization. In terms of 11, they are not entitled to access the records and documents in my possession during the course of my investigation. In terms of Section 11 of the Public Protector Act, any person who contravenes the provisions of Section 7(2) is guilty of an offense which is punishable by a fine not exceeding 40,000 or imprisonment for a period not exceeding 12 months, or both such fine. Kind regards, Advocate Busisiwe Mkhwebane, Public Protector, 5 June 2019, page 66. That was then the sum total of what was presented to, and I think the one to Mr. Godan was 71 pages. So we're not going to go there, Chair, after this. But the point really of us going through this is to show the exact, as I say, I mean, I'm not being funny about this. I have never seen a letter this long and with so much technical detail. So can you maybe take the commission, the inquiry into what is involved in the compilation of something like this, with all this detail and this act and that act and this charge and that charge and this list of equipment and what have you, list of names, in order to give the person an opportunity to defend themselves? From someone like you now, because you really, the letter originates from you, the public protector approves or disapproves or changes it here and there. We all know the story by now. But what does it take? The kind of blood and sweat that it takes for you to put something like this together?
Firstly, the most important part before you start even drafting is to analyze the documents that you've received that are before you, to see what they say. If they are relevant, you know when to put them in, and if they're irrelevant, you know where they go. So each issue then is separated as in the report. The allegation is separated. All the evidence relating to each allegation has to be in that allegation. And then you draft, you summarize what is on paper and put it to make it read well to the whoever will be the reader. So that will include summarizing your evidence, noting the important parts of the evidence which deserve to be in the report. Once you go through that for each issue, your writing style will be different. Others prefer to first incorporate the evidence in all the issues and then only go into the legislation. My style is a bit different because I like to first analyze the legislation for each issue so that it will be easier to remember the evidence whilst applying it to the law so that you can come to a conclusion. That will then happen for each and every issue until we get to the findings. You then make findings based on the law and the facts. And now we put in the remedial action, but at this point in time, we had not put in the remedial action in the Section 7(9)s. Once you're done with your draft and you check and double check again, you then submit it to your chief investigator. Your chief investigator will make inputs, make changes if necessary, include information that he or she also remembers, send it back to you for incorporation. That can happen for a couple of times, sometimes 5, sometimes 10.
No way.
Depending on what is missing. If certain information is identified as missing, you would then go back to how do you obtain that information. So if it's necessary to go back to the department or a particular individual, you'll then write to them again or request a meeting, etc. Once that is done, it will go through the 7 stages that you talked about, or 5 stages. And each person will then, the 5 stages will be your EMs, your ACOO, until it finally reaches the PP. And before reaching the PP, it's back and forth with incorporating inputs of comments made, inputs made, until the final draft is then approved that it is ready. Usually in this case, it was the chief investigator. And then it was submitted to the PP. PP also reads it, goes through it and makes inputs, sends it back on things that she wants it incorporated, or we will have a meeting to discuss the section 7.9, and maybe if she doesn't understand something, why a certain conclusion was reached, etc. So in all of these instances, everyone applies their mind until the final product is done and it's signed and sent. Once it's sent, we await responses to section 7.9. Once we receive the responses, we go through the responses and really go through the responses to see that, to make sure that the arguments that we have made or put forward, or the conclusions that we have come to or potentially might come to, are addressed by the respondent. Once that is done, we then incorporate the responses in line with the particular allegation. So we won't just dump your response in an allegation that's not relevant to it. And in this instance, there were a lot of, like you were saying, the allegations of bias and accusations of non-application of the 6.9. So you find places to put that in, and then you address it if necessary. Responses that are rude, or we would consider rude, maybe saying something not nice about the public protector, will note, because if it doesn't relate specifically to the allegations, we can't be having a debate with you on the section 7.9 or on the report. So once those are incorporated and all of those are considered, a final report is then produced. If your response or negated our potential findings, and then once we go through your evidence, we do make a finding. Like, for example, you stated that you then provided the slip for the water bottle. We cannot then make an adverse finding against you if you've provided us with evidence that shows that the allegation is unproved. It will be removed from the final report. If the evidence is not submitted, we proceed with the adverse findings. And then the final report will then go through, let's just assume we're making the adverse findings with or without the actual removed allegation if you've submitted the evidence. In that instance, the roller coaster of approval starts again. So it's still checked and rechecked and resent and checked again and resent until it reaches the public protector, who does the same, makes inputs, discussed, and then once we are happy that, okay, the product is ready, it is then issued.
Yes,
That is the end of the investigation.
yeah. Thank you. Yeah. That sounds like I don't know, a military operation. But, you know, we talk so much about all these mechanical things, and I think we forget to be human. So let me ask you this. At a human level, how does it feel for you, having put yourself through all this, what you've described now in detail, having had a letter like this, going up and down, being corrected, recorrected, and all sorts of things, at the pain of trying to be fair to the people who might have adverse findings. And then to get, you know, people who probably would not even be able to put a 5-page letter of this kind of complexity. Or let me maybe just say, how does it feel when somebody like Ms. Mazzoni, MP, then say reduces all this to, you were just going through the motions because you just wanted to, you had a vendetta against Mr. Godan. So all this was just play and pretense.
It's offensive, as I stated, of even the allegation that I was involved in a conspiracy of vendetta against a person I don't know personally, and really my integrity as an investigator for all these years. How many investigations have I conducted and what made him that special? So it is offensive and not appreciated. But like you said, they don't work at the public protector, so they'll never know what it is.
Yes. Thank you for sharing that. And just you know, more than all of us sitting here, how much the public protector herself now puts into something like this. You've described the drafts going to her, coming back, going to her, coming back, having discussions, and what have you. In your experience, what you observed in this particular case and how much work was done, knowing that particularly EMEA investigations have to invariably be done under pressure. What do you say about the suggestion that she did not do any of this, or she did not do it genuinely, and she was just out to lynch an innocent Mr. Godan, Mr. Pillay, Mr. Mahashule?
I would say, from my experience and what I was exposed to during the time I worked with her during this investigation, I never had any doubt that there were media reports, of course, that came out alleging Mr. Godan would say there's someone on a witch hunt for him, etc. But I never experienced that kind of behavior from her. She didn't at any point try to influence us to say that we must make a finding against Mr. Godan. And we must ignore certain evidence so that we can make a finding. Yeah, it's sad.
It's very sad. Thank you. And on that sad note, then Mr. Godan, actually, we said earlier that he's the source of why we're here, although he's being shielded from coming to substantiate it here. But we have to defend ourselves against his non-appearance or not having the conviction of and the courage to come here and face the committee to substantiate this. But among the things that he claimed, if we can go back to the Mr. Godan's response to the section 7.9, which you'll find at 5931, I think, of bundle F, item 190. This is really what brings us here. And obviously he then expanded on this in his court papers, and then the judge is found in his favor. Hence we're here. Go to the last page, 5952. After giving the explanation, which is it's about 21 pages. At page 23, this is the conclusion that Mr. Godan then reaches, which brings us here, as I say. The public protector's proposed findings against me substantiating complaints laid by my political opponents are unfounded and are explicable only by bias or ulterior motive. I call on her to reconsider the true facts and the applicable law and find that I am innocent of any wrongdoing. Let's put aside the fact that he's not prepared to come here to do so. But what do you have to say that all the work that you had put in can be explicable only by bias or ulterior motive?
Like I previously said, Mr. Mpofu, there were no elements of bias or ulterior motive that I saw or received from the public protector. That's why I always question a statement like this. Okay, does he have proof that we had ulterior motives? An email saying that I wanted to persecute him for something? Because no, I don't agree with the statement. My work was not biased and or had any ulterior motives towards Mr. Godan.
Yes. And paragraph 51 of the same document, going backwards, Tsepo. He says, the establishment of the unit was perfectly lawful. You obviously have said that you don't agree with that, correct?
That's correct.
And then here's the important part. The public protector's proposed findings to the contrary are wholly unjustified, erroneous, and intended to serve a political purpose or other ulterior motive. What do you have to say about that? And that's really the gist of the charges 11.3 and 11.4, that for political purposes, she chose her favorites, Mahashule and Mvuyana, for being spared of any adverse finding, and targeted her alleged opponents, Ramaphosa and Godan, to serve a political or ulterior purpose. Is there any basis for those charges or this accusation?
On our side, or on my side, or on PP's side of the court, if I would say so, there wouldn't be any basis on this. Unfortunately, as the public protector, South Africa, we don't choose who walks into our doors and complains. So I think he said the statement on the basis that Mr. Shivambu belongs to the EFF and there's a political opponent of the ANC. However, even with that knowledge, we can't stop an investigation because the complainant is from an opposition party.
Yes.
Yeah. There was no political purpose. There was no political motive to discredit him. It was just about a truth-finding mission of a complaint that we had received.
Yes. And let's suppose for a minute that Mr. Shivambu had a political motive. That's not the issue. The issue is whether you and the public protector and the people in your team then, as it were, embraced that political motive and did anything unprofessional, dishonest or biased in order to pursue it.
No, none of those happened, and we did not embrace any political issues.
Yes. And in any event, if that this is to be taken to its logical conclusion, it would mean we must repeal EMIA. We must not have such an act, because the chances are that it says it must always, the complainant must always be a member of parliament. And at least with the current legal system or political system in South Africa, those people who are members of parliament are always members of political parties, isn't it?
Yeah, that's correct.
And the parliament, in its wisdom, knowing that all members of parliament are members of political parties, allowed that the public protector must act in terms of an EMIA investigation only on the basis of a complaint by such a political person, correct?
Yes, that is correct.
And as we have established, all EMIA investigations, including the current Pala one, emanate from a member of a political party, correct?
As far as I'm aware, yes. Unfortunately, I'm not involved in that investigation and never even seen the complaint form. So I'm not sure if, but media statements have stated that.
Yes, no, but even if you've never seen it, if I tell you that it's an EMIA investigation, then automatically it means it would have emanated from a political, a member of a political party. You might not know who that is, but it would have to be a member of a political party.
Yes, that is true.
And by the way, EMIA investigations such as that Pala one would have to take about 30 days, correct? In terms of the law, are supposed to take 30 days.
Yes, in terms of the act.
Yes, and we know, I think evidence has been given here that it's usually difficult to achieve that depending on the complexity of the matter. So it might take 3 months, 4 months, depending on the complexity of the issues, correct?
Yes, that's correct.
But if the issues are straightforward and seemingly, and I know that they might look straightforward to the naked eye, can it take longer? Can it take like 9 months, 12 months, 2 years? Or do you, maybe let me ask it like this. Is it the culture within the public protector that such investigations, particularly ones that are important to the public, like this one, would have to be prioritized? And even if you miss the 30 days, that it should not be too far, correct?
Yes, especially with EMIA investigations.
Yeah. All right. Okay. Now, let me, while we are in this document, Chair, sorry, just for the sake of completion, I found something that I had been looking for earlier. Paragraph 26. Sorry, okay. Now, this is Mr. Kodan under oath in his own words. The Mr. Kodan that we're told is irrelevant to this commission, to this committee. Actually saying the following. Let's go to paragraph 22, sorry. During my tenure as Commissioner of SARS, I authorized the establishment of an investigation unit in about 2007. The unit did not initially have a name, but it was later successively known as the Special Projects Unit, the National Research Group, and the High Risk Investigation Unit. I shall call it the unit. So on Mr. Kodan's own version, he agrees that he established the unit, correct?
Yes.
So the only issue then would be the issues that we have already discussed as to whether that was knowingly illegal as indicated in the letter to Mr. Manuel and all that. I won't go back to that. I just wanted to establish the fact that he says he established it himself, correct?
Yes, a unit.
Yes. No, the unit. In other, with all the different names, Special Projects Unit, the NRG and High Risk Investigating Unit, which he says I shall call it the unit. Okay.
Yes.
Yeah. And then at paragraph 26, he says, yeah, and this is the important part. That's the issue I was talking, you know, they say in law, at least, or in even in logic, a small word like the or a, the difference between that can make all the differences, all these piles and piles of paper. This is what he says, and you must look at the last sentence where he used the word the unit. Listen carefully. Mr. Kodan says under oath, it became apparent to SARS, this is now after the Trevor Manuel memo, yeah. It became apparent to SARS that it had to enhance its capacity to gather information of and investigate organized crime, right? It, that is SARS, decided in or about February 2007 to set up the unit to penetrate and intercept, okay, the activities of tax and customs related crime syndicates. So he admits that it was necessary to intercept, among other things, which is what we discussed earlier, correct?
Correct.
And which we know would have required the approval of a judge in South Africa, at least, correct?
Well, we would need to check if the Interception of Communication Act was in effect in
existence
2007.
Yes, I think it was. I think it's 2002, but assume for now that it was in existence. That would then require the permission of a judge, correct?
Yes, that's correct.
Right. And then it says its initial intention, that's the SARS, was to employ and train the members of the unit and then to transfer them to National Intelligence Agency, where they would continue to function as a unit dedicated to SARS. So that's along the lines of his memorandum to Mr. Manuel, correct?
Yes, that's correct.
Yeah. Which said that the reasons for him wanting to do that was that they did not have the legal power to do so, correct?
That's correct.
Yeah. Then he says, the NIA, however, lost appetite for the project, which is understandable. So NIA no longer was playing ball, okay? Here's the important part. It says, SARS accordingly decided to retain the unit within its enforcement division. So this is what I'm saying. So he's still talking about the same unit, which was illegal, which they were going to transfer to NIA to make it legal. And NIA lost appetite, and then SARS accordingly decided to retain the unit within its enforcement decision. This is Mr. Kodan in his own words, correct?
Yes, that's correct.
And this seems to accord with what you said earlier, that the unit never changed its character. It was simply no longer going to be transferred to SARS, correct?
Yes, that's correct.
And then here's another giveaway. He says that one of the reasons why they wanted the approval of the Minister of Finance was because, I suppose, let's call it PFMA compliance, because the unit would have involved transfer of funds from SARS to NIA.
Yes.
Yes. So he then explains that that transfer of funds was no longer going to happen. Hence, they no longer needed this approval, but says nothing about the illegality, the fact that it was still illegal for a different purpose. Let's go to paragraph 32. Says, okay. This plan required the approval of the Minister of Finance only because, oh, sorry, I'm sorry, 31. This plan required the approval of the Minister of Finance only because it would involve a transfer of funds from SARS to the NIA. Now, you'll remember, if you don't know this, don't worry, because we'll canvass it with the PP. At some stage, there was approval needed from the Minister of Finance on the one hand, but also the Minister of Intelligence. Are you aware of that?
Yes.
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 Yes. So let's accept what Mr. Kodan is saying here for a minute and say, therefore, the approval as far as the transfer of funds would be acquired from the Minister of Finance, but the approval to cure the illegality would be acquired from the Minister of Intelligence.
Yes, that's
Right.
true.
Yes. Now, he did not obtain, well, he obtained the approval for the finance, but he did not obtain the approval from the Minister of Intelligence to cure the illegality, correct?
Yes, that's correct.
Yes. And yet, this is what he says at paragraph 32. As explained above, the NIA, however, lost appetite for the project, so he never received the approval from NIA and decided not to proceed with it. That's common cause, okay? And then he says SARS consequently decided to keep the unit in SARS. This change of plan did not require fresh ministerial consent because it no longer involved the transfer of funds from SARS to the NIA. Now, that's what I call an exercise in obfuscation. So assume he's right that the financial transfers were no longer going to happen, but he's also conceding that the NIA approval to cure the illegality was never obtained, correct?
Yes, but he puts it now as a loss of interest.
Yes. Well, whatever, loss of interest, immigration, whatever the reason was. But the point is that he did not get the approval to cure the illegality, correct?
Yes, that's correct.
And then it says at 34, this is the punchline. I accordingly participated in the approval of the project for the establishment of the unit. I was, however, not involved in the practicalities of the establishment of the unit and never played any part in the conduct and management of its operations. Again, let's be fair to Mr. Kodan, even if he doesn't want to come here and face the music, that he didn't participate in the actual bagging of people and surveillance and so on. You never found him guilty of that, did you?
No.
But what you did found him responsible for is what he admits here, which is he accordingly participated in the approval of the project for the establishment of the unit.
Yes.
Thank you. And then at 35, he says, I believed that the unit was lawfully established to perform very important functions for and on behalf of SARS. As far as I was aware, it lawfully performed its functions. If any of its members engaged in improper and or unlawful activities, then they did so without my knowledge or consent. Again, let's be fair to Mr. Kotan, even though he doesn't want us to come here. Let's assume the unlawful activities happened without his knowledge. That's not what you are accusing of. It was the establishment of the unit, correct?
Yes, that's correct.
And in any event, in our law, does it matter what he believed or did not believe? He says, I believe that the unit was lawfully established to perform a very important functions for and on behalf of SARS. Is the test of whether there is a breach of statute or the PFMA objective or subjective? In other words, if I breach the PFMA thinking that I did not breach it, does that make the breach any lesser?
No.
And the public protector agrees, and the KPMG, and Sikakane, and the Inspector General, and Brasi, and Trengrove, and Kruan, and anybody with even half a brain would agree that the test, and one who's not even a lawyer, that the test for breaches of PFMA is objective. In other words, if an official buys 20 buses when he's only entitled to buy 10 buses, whether he believed or he couldn't read properly, doesn't matter, even if he genuinely believed he was entitled thereto, correct?
That's correct.
So on this version of Mr. Gordon, by himself under oath, signed before some commissioner of oaths, known as Mr. Peter Jonathan Isaacs or whatever in Cape Town on the 20th of June, 2019. On this version of his, would he have been, would the findings of maladministration in respect of the establishment of the unit have been established?
Yes, he's based admitting that he was,
sorry, there's interference from the rogue unit. Can you start again? You're saying he's basically
admitting that he was involved in the establishment of the unit. Yeah, if you can read it carefully, it says that he was involved in the establishment and he knew that it would have been an intelligence unit because that was written in the memo, 2007.
And does the fact that Ms. Mazzoni and the rest of them say that this is proof of you and the public protector's vendetta against Mr. Gordon, can it stand any scrutiny in the light of what Mr. Gordon says now? Forget about what the public protector says, forget about what anyone else says, of what Mr. Gordon says in his own affidavit.
Can you please repeat the question?
Is there, therefore, yes, sorry. Is there, therefore, based on what Mr. Gordon says in his own affidavit in response to your Section 7.9 letter, your detailed Section 7.9 letter, would there have been any room for anyone to say that faced with this response, which is really basically amounts to a confession, that you should have then changed your provisional findings and now find all of a sudden that Mr. Gordon was no longer responsible for the unlawful establishment of the unit?
No, I don't believe so.
Yes. In other words, what I'm really asking you is, we've gone through the journey of what a Section 7.9 is meant to do, the opportunity it gives to a person. And by the way, is it correct that when you sent the Section 7.9, Mr. Gordon asked for an extension. I would too, by the way, faced with such a complex letter. But then he asked for more time for him to give the response, correct?
Yes, that's correct.
Did the public protector grant him such an extension?
Yes, even in his first submission, he was granted an extension.
Yes. And once he was satisfied that he had had enough time to deal with all the accusations, what he gave you is what amounted to a confession of illegality, correct?
That's correct.
Thank you. Chair, I'm not by any means finished, but
Fortunately, your time is finished. And that's a difference in the way we
No,
operate.
I know, Chair.
So I'd
But,
like you to wrap up, please.
I'm asking for time, yes. Chair, well, okay. I'm going to wrap up, Chair, I promise. I just have maybe 3 or 4 topics. I'll do them as quickly as possible. What I wanted to get an indication from you was whether, I think I need about an hour, whether you want to give it to me now or tomorrow morning.
We'll do it now.
Okay, Chair. I won't use it all up. I promise. If I can. Okay. Thank you. All right. Let's go back to the famous judgment that brought us here. So you'll find that at page 4118 of the of that bundle of judgments, except for, I can't remember what it is now, but it's paragraph 200, I think, or no, 290 of the judgment.
Which judgment are you wanting to go to?
Okay, the one and only so-called rogue unit judgment.
So see bundle 319.
Yes, I think it's bundle C. Sorry. Yeah, it's bundle 3. Bundle C number 3, judgment 18, something like that. That's how Advocate Power identified it earlier. We just dealt with it now about the matric certificate.
Advocate Mpofu, which paragraph do you
Yes.
want to go
Oh, sorry. I didn't see that it was up here. Yeah, it is that paragraph 290. Thank you, Chair. Yes, this paragraph really summarizes why we're here, why the judges found it necessary to make the conclusion of bias and dishonesty. So they say correctly that if you have findings of bias and dishonesty, assuming that those are justified, that this was then it justified an inference of bias. So they say, paragraph 290, we have already alluded throughout the judgment why we say that the public protector has not only failed in the exercise of her duties, but displayed bias towards Minister Godan and Mr. Pillay. So we conclude that taking into account the following conclusion, rather the following comma, a conclusion of bias is warranted. Then they list the things, some of which you and I have discussed and shown to be to have no foundation either in fact or in law. But let's go through them. The first one is something where you and I have not discussed, and since we don't have time, I'll only spend 5 minutes on it. They say that the investigation fell outside the jurisdiction of the public protector as it relates to events dating back to 2010. No exceptional circumstances have been presented by the public protector justifying the investigation after an extraordinary lapse of time. Also, despite that fact, the previous incumbent has already in 2014 received a complaint about the alleged unlawful establishment of the unit, but elected not to investigate the complaint. Public protector proceeded with the investigation. Firstly, is this factually true? Okay, no, let's not start with the facts. Let's start with the law. In your experience, and hopefully Advocate Madonsela will assist us in this as well. In your experience, was there a blanket prohibition against doing investigations when the matter was more than 2 years old?
No.
And whose decision was it, or how did it work that such a matter would be considered?
It's based, the determination of the jurisdiction is based on the public protector applying her discretion. At the time when this investigation started, and in some instances that delegation is, or the discretion is delegated to the intake and assessment unit, who then makes a determination of whether the matter falls within or without the 2-year rule, as we call it. So if they determine that it is 2 years and older, then they will then take a decision of whether or not to proceed with the investigation. So at the time, the decision to accept the complaint, because if the decision, the jurisdiction is applied strictly by intake and assessment, the complaint would not have been accepted. But now it was accepted, basically on the basis that we've never not investigated 2-year-old matters unless it's a pre-1994 matter. But if, or let me say 95, but if the public protector or the units that I mentioned is satisfied that there's merit to the complaint, the possibility of investigating, finding the information still exists, the public protector will continue to investigate. So jurisdiction is not taken away because the matter is older than 2 years.
Okay.
From our understanding, though, when we started the investigation, the courts have also have found otherwise, of course. So
yes. Thank you. Yes, subsequently. Yeah. In fact,
Yes.
to be fair to the courts, they said, I think in the Pillay judgment, at the beginning of that judgment, the court says that it's the first time that Section 6(9) of the Public Protector Act, which is the one that you've just paraphrased, was being considered by the courts. But obviously this was, in fact, that's referred to in this judgment as well, because those two judgments came around the same time. Chair, okay, I'll find the reference. But anyway, I know because I argued that point in both matters. But long and short of it is, yes, you're right. Until that point, it had never been considered by the courts. It was considered in those two cases and then in the James case as well. Whether the 2-year rule was, as the court interpreted it rightly or wrongly, was like a prescription kind of thing, which says 2 years, otherwise you cannot investigate. Or whether, which is what the public protector argued, it was all actually, because it is found in Section 6, which gives the wide powers of the public protector. It was a permissive section, which says if the public protector thinks that a matter is important enough, whether it's 200 years old and the evidence is still there, then, and she feels that it is important, then in her discretion, it can be investigated, yes.
Yes, that's how
it had been approached until that point, yeah. Okay. So if then that's how it had been approached up to that point by all the public protectors before, could that then be an indication of bias?
I won't know about all the other public protectors, how they applied or interpreted 6(9). But under the two that I've worked under, no, it would not.
Okay, who are those two?
Advocate Mrs. Mvuyana and Advocate Chulima Donsel.
Right, thank you. And anyway, the proof of that fact is even in this paragraph. It says in 2014, the former public protector of Madonsela, because that was her time, received a complaint and elected not to investigate the complaint about the unit. But this public protector nonetheless proceeded with the investigation. Firstly, was that factually true? Was the complaint, the earlier complaint, about the establishment of the unit, to your knowledge?
I believe it was one of the allegations, but I'll have to go back and check the closing report. But what is elected not to investigate? She might have elected not to investigate because, and claim when stated from the report that I saw when I was watching Mr. Matabuch, that the reasoning for not investigating that portion of the investigation was due to the fact that the OIGI and the NPA had already either began their investigations or were busy with the investigations.
Yeah. Okay,
yeah.
No, that's fine. Mr. Matabuche, Advocate Madonsela, hopefully will clarify that. But the point is that, anyway, the point is that even by 2014, that the establishment of the unit was already more than 2 years old, correct?
Yes, that's true.
Okay. The next one, then they say that the manner in which Mr. Pablo Pereira interacted with Minister Kodan during the investigation, addressing the report, not only did Pablo Pereira elect not to engage with Minister Kodan's attorneys on record, the Section 79 notice was publicly posted on YouTube before giving any notice to him, his attorneys. Similarly, the report was presented to the media without any prior notice to Minister Kodan or his legal representatives. Okay, all of which will be dealt with by the public protector in her evidence. But for your part, you've already answered this, that you put blood and sweat in ensuring, and the public protector, in ensuring that the Section 79 was as detailed as humanly possible and as fair as possible, correct?
Yes, that's correct.
And actually, is this also factually correct? Does the public protector ever publish Section 79 notices on YouTube or anywhere?
None that I know of.
Yes.
No.
Remember when I read it out to you, the last paragraph says that even the person receiving the 79 is not allowed to share the contents thereof with any person. Correct?
Yes, it's confidential.
Let alone the public protector who then issues that warning, and then she goes and puts it on YouTube. Anyway, all right. Then on number 3, they say the reliance on the discredited KPMG report, despite having been disavowed, and Skakane report, despite it having been widely discredited. Well, we've gone through this. There's no substance in the Skakane report being widely discredited. And the KPMG report, we did not go through it in detail, but I will deal with it maybe with Mr. Matabuche. You can take it from me that it was not totally disavowed, but parts of it. The KPMG basically said that they relied on counsel's advice without having verified that advice. But you don't have to worry about this. But the Skakane report being widely discredited, do you have any knowledge of that?
No, I do not.
And then it says, she also failed to engage with the findings made in the Nugent report. Is that possibly true?
No, that's incorrect.
We demonstrated earlier that the new public protector quoted the Nugent report in the letter to Mr. Kodan. She quoted it in the letter to Mr. Pillay, and I'm sure in the letter to SARS, and that she even quoted it in the final rogue unit report, correct?
That's correct.
And then number 4, it says the blatant dishonesty of the public protector with regard to the OIGI report and her insistence on ordering Minister of State Security to implement in totality a report that she has, according to the report, never seen. Well, we know that this one is an absurdity because she never claimed in the report that she never saw the OIGI report. We dealt with that before lunchtime, correct?
Yes, that's correct.
And then number 5, it says the public protector pandering of the rogue unit narrative and her public reference to the unit as a rogue unit and as a monster, and her stated desire to defeat the monster displays profound bias towards Minister Kodan and Minister Pillay. Well, firstly, I think you and I have established that when the term so-called rogue unit was coined in the KPMG and Skakane reports, the public protector was busy working in China and not involved in any of these matters, correct?
Yes, the term was not created by her.
Yes, and in any event, this is also factually not true. You can take it from me, and my learned friend, Ms. Bauer, will object if I'm correct. In the article that was referred to, or rather the speech, which was read here during Mr. van Lochenberg's evidence, actually the public protector referred to this thing as the so-called rogue unit in that speech. So, and that term, so-called rogue unit, was it also her invention?
No, not that I know of.
Right. And her evidence will be that the monster that need to be defeated was a monster of corruption, but you don't have to comment on that. She will deal with it herself. Then number 6 is the public protector's complete disregard of the Sunday Times apology and the Kroon apology. We've gone through that. The so-called Kroon apology was for Judge Kroon himself, not the panel, correct?
Yes, that's correct.
And the Sunday Times apology, well, what can I say? All right. So, and the public protector was now supposed to alter a report because the Sunday Times has decided to retract something. Is that how you work?
No.
Yeah. And then says the public protector has scurrilous allegations that Minister Godan deliberately misled. Well, this is wrong grammatically. Probably wanted to say misled. Deliberately misled Parliament. But forget the grammar. Let's just you don't know, or rather you know about that allegation, but we have not gone through it. That's the allegation about the meeting with the Guptas and so on.
Yes, I know about the allegation.
Yeah. And in your assessment, and I won't go into detail because of time, was that allegations also substantiated that Mr. Godan, let's say, was not forthcoming about his meeting with the Gupta brothers?
Yes, it was substantiated.
Yeah. Okay. And then the public protector's unwarranted and slanderous attack on Judge Potteril J. She'll deal with that. This is that whole confusion about whether it was the 2000 code or the 2007 code. Don't worry about that. Then the public protector's relentless pandering of untruths of Mr. Pilay's qualification. We've dealt with this one. Did the public protector pander untruths of Mr. Pilay's qualification to your knowledge?
No, not to my knowledge.
Right. So that's why we're here. Because of these findings, none of which you have found to be congruent with the actual situation, to put it nicely. Except for the one, yes, the one that I said you must not, let's say 8 of the 9, you, in your experience, were not a correct basis for the finding of bias, correct?
Yes, that's correct.
All right. Then there was a whole thing, we don't have time to deal with it in detail. I might also deal with it with Mr. Mataboga. There's a suggestion that the public protector or you or Mr. Mataboga or your team ignored. Okay. Okay, I think that I'm being intercepted.
Apologies, somebody was switching on. Please continue.
Okay, Chairperson. Are those people, are they properly employed by Parliament?
It's not official.
Okay.
To be one of the members, I think by mistake. They would have
Oh, I
pressed.
see. Okay. We are worried these days. Yeah. Okay. Now,
The proper explanation is that there's somebody who would press that was watching TV at the same time. Those who are on 4.
then there's an
Yeah.
echo.
Yes.
Okay, thank you. Well, thank you, Chair. It's better than what we saw last week on the screen. But Yes. This is what the court says at 293. The public protector's bias against Mr. Godan and Mr. Pillay is manifest, having regard to the manner in which the public protector simply dismissed out of hand, completely ignored and irrationally discarded the hard facts and clear evidence. It is clear that she approached her investigation with a preconceived notion, determined to make an adverse finding against Minister Godan and Mr. Pillay, thereby promoting the false rogue unit narrative. So you see now here, this is a mirror of charge number 11.4, 11.3 and 11.4. So it means you, Mr. Matabucha, the public protector, discarded hard facts and clear evidence because you were chasing a preconceived notion and determined to make adverse findings against Mr. Godan and Mr. Pillay, thereby promoting the false rogue unit narrative. That's what the judge has said. Is there any substance to this?
No, which discarded hard evidence and I don't know, have you moved the paragraph?
Oh, sorry, it
Careful.
goes to the next page, yeah. It's okay, I'll read it again because it's quite a serious accusation. It is clear that she and you and the others approached your investigation with a preconceived notion. Oh no, sorry, let's start with the evidence. Blah, blah, blah. Simply dismissed out of hand and completely ignored and irrationally discarded hard facts and clear evidence, supposed to the contrary. And anything like that?
No.
Anyway, so it goes. That's fine. Then I'll move because of time to another topic. But maybe before I do that, let me just quickly deal with there's another quick accusation, for lack of a better word, that is bandied about against the public protector, but I won't spend time on that because I think even witnesses that were clearly hostile and biased against her considered the point. But just for the sake of completion, the public protector has been accused of all these horrific things, among other things, because of information that may or may not have found itself in Rule 53 records. Remember that?
I think so, but that accusation. Yes.
Okay. Now, can you explain why that accusation is baseless?
Towards the public protector.
Yes.
The public protector is not involved in putting together the Rule 53. All documents and evidence is mostly with us, except certain recordings, which in this case was the SSA meetings and the minister meetings. Those we had to request directly from Ephraim, the PA. But documents that were in our possession were all compiled into the Rule 53.
Yes, I think again, okay, for the sake of time, I'll just read out paragraph 44 of your statement at page 462 of the statement, Chair. You say, I can confirm that the public protector had nothing whatsoever to do with the compilation of Rule 53 records. That task is not even performed at the level of the executive manager. It is performed by the investigator, that would be someone like you, as the person on the ground with the assistance of the legal department or the external attorneys. Is that how it works at PPSA?
Yes, the investigator leading the investigation is the one who compiles the Rule 53.
Yes. So if a particular Rule 53 record, because of either you or the attorneys or the internal legal department, did not contain one document or another, could that be a basis for impeaching the public protector?
No, I mean, as we've said, there's human error in every situation. Even I was assisted, the amount of documents that were there. So if it did happen that a document was missing, it would not fall on the public protector. The external attorneys as well would have had to request it, etc. So through the legal department, but the PP, no.
Yeah. Okay, let's take it to absurd lengths and say that either the external attorneys or the internal attorneys or yourself or somebody in that process, not by human error, but deliberately, one of them decided to take out a particular document. Could that be ascribed to the public protector if she doesn't participate in that process?
No, I don't, she doesn't even see the Rule 53 or confirm that it's been sent to the legal department or check the documents that are submitted, etc.
Yeah.
So she wouldn't have had access to it.
Thank you. All right. Okay. Now then, okay. You then say at paragraph 42 and 41, and I think it's important to read this. You've said it in different ways today, but I just want to put it in your own words in the statement. Yes, say I'm starting at 41. The public protector plays no role, no active role during the investigation, as I have demonstrated above, even at the assessment of the merit of the complaint. I myself, a person who investigated and produced the report, had no relationship or sympathies with Mr. Shivambu, the complainant. He was treated like any other complainant. The public protector did not interfere with the investigation, neither did she try to influence the outcome of the investigation, including the findings as contained in the report. Now, please explain this, because very briefly, it's another gray area. We know, as you've said repeatedly, and other witnesses, that, as you said, documents go up to the public protector, documents come down. Sometimes she issues instructions, do this, do that, or give deadlines in dashboard meetings or whatever. But apart from that supervisory role, does the public protector actually play any role in the actual investigation? In other words, in evidence gathering, phoning SARS and this one and that one?
No, she does not.
Okay. And then you also say, sorry. Yes. And in situations where, I'll deal with Mr. Matabucha for lack of time. In situations where the public protector receives, and I'm sure all public protectors receive, information on a daily basis from citizens, all sorts of whistleblowers and so on, what does she normally do with that information?
It's in this case or in general?
In general, and in this case.
Okay, in this case, information was filtered through Mr. Matabuche. In general, it's sent to Ephraim, who then ascertains who is responsible for that particular matter, and the information is handed over to the relevant investigator of the matter. Yes,
and thank you. Well, there was even a suggestion made here last week that there was a document which was read, I think it's at page 5978, where it is said that somebody wrote that Mr. Kodan must be, I don't know what, the thing, must be stopped with all sorts of political reasons why that was so, but white monopoly capital and what have you, yeah. And the public protector, oh yeah, 5978, okay, thank God I remembered the page. Oh, yeah, okay, then just go to that, at the top. Pravin Gordhan is a threat to democracy and must be stopped before it causes more harm under the guise of cleaning up, and so on and so on. Now, the evidence of the public protector will be that that is something that was sent to her by a whistleblower or by whoever sent it, but someone who did not want to be identified. And as you say, then she would transmit it to the team. Is that a usual procedure?
Yeah, it depends what the email was about. Besides threat to democracy, I think there are various matters that are discussed in this complaint that were being investigated at the time. So same procedure goes to the relevant chief investigator, or through Ephraim, then either through the assistance of intake and assessment will find out which matters belong to which investigator, and then the information is dispersed. But I've never seen this email, so
Yes.
I
Okay.
won't necessarily know what happened to the information contained in it.
Yes, okay, let's go to the beginning of that email. Tsepo. Okay, it's that. The email is dated 8 November 2018. It's to Rodney's from the public protector, and it says some information for investigation BBND. What was BBND?
It's an investigation against SARS relating to the appointment or the alleged irregular appointment of a company called Baron Badge and Doran, so
Yes.
abbreviated BBND.
Yes, and then you can see that the email, well, okay, it just starts in 2001. There's no greeting, no reference to any person. Just says in 2001, the former minister Jeff Radebe wrote a scathing letter to Coleman Andrews. What have you, and so on. Is that, in your experience, is that how the public protector would write her emails, just without any preface?
No, and she likes summarizing, so this is very detailed.
Yeah.
When she's passing on information directly to you. This is like someone telling a story.
Yeah, well, okay, because we don't have time, I won't go through the detail, but this, just go further down. It refers to something called the Nugget Commission. And yeah, there, at the Nugget Commission.
Nugent, I think.
Yeah, well, it's Nugget, according to this person. Did the public protector not know that the commission was by Nugent and not Judge Nugget, whoever that is?
I believe she would have known.
Yeah. Okay, anyway. Anyway, it raves and raves. The difficulty with this is that we actually have another email, which, Chair, if with your permission, I'll refer to it in re-examination, which is similar. The only difference is that that one, the person is identified. And in fact, the public protector's evidence is going to be that in that one, she simply forgot to remove the person's name because she And so we will, when we play it, it
Yeah.
will be,
Is that an email that we have seen already or received?
you
Or
have received,
You'll
but
only introduce it in then.
no, it's here, it's in the package, Chair. The reason why I'm saying this is because I'm in a dilemma. I could display it now, but then I'll be disclosing the person's name. But in fact, it's my fault. What I had intended to do was to redact the name and so that it can be done here, but we didn't do that. Yeah, but it is in the package, Chair. Yeah. Anyway, I think the point is made for now. If there's no objection, then we will play that, or rather display that other email. But the point really is that if you look at this, and you've already commented about the style and the misspelling of Judge Nugent and all those things. In your knowledge of communications with the public protector, is there something that would be coming from her in your experience?
In my, no, this comes from a complainant. We receive a lot of these. Once the complainants find out that we are investigating certain matters, because I see Bain and Co was also one of the allegations that were made. And then the SAA, I don't know anything about. And Mango, no. But the way that the email is detailed, it sounds like it comes from a complainant.
Yes.
It's detailed and no offense, all over the place.
Thank you. Yes, and then I think there was another embarrassing confusion which you can help us with. There was a suggestion, well, I don't know if it was persisted with, but there was an email which referred to ACE, and it was suggested that there might be Ace Mahashule. At the public protector, ACE and ACOO, what do those abbreviations stand for?
ACOO is Acting Chief Operations Officer. ACE would be Acting Chief Executive.
Thank you.
So either Executive Manager, they have that.
If they have, yeah. Okay, thank you. No, I think that was made clear, but I mean, it just shows you the kinds of things that we get subjected to. But then the last point before I run out of time is, okay, sorry. I just want to read this out as well. You say, blah, 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 blah. But paragraph 42, I'm also not aware of any decision taken by the public protector or the chief investigator, which was not based on an honest opinion and unsupported by the facts. Do you stand by that? That's paragraph 42 of your
Yes,
statement.
I stand by it.
And then you also say, I never got any impression of any undue influence by the public protector, neither did I get an impression that she was forcing the team towards a particular outcome. Do you stand by that?
Yes, I do.
And then I'm jumping 40. Oh, no, let me not jump it. Paragraph 45, you say, it is therefore my testimony that the allegations contained in charges 11.3 and or 11.4 of the charge sheet have no factual or evidential basis insofar as they relate to the so-called rogue unit investigation and report, which was conducted honestly and impartially, irrespective of whether one agrees or disagrees with the findings and or remedial action. Neither did the public protector nor any of her subordinates involved in the matter, including me, acted improperly or maliciously or even negligently in carrying out our respective official duties. The allegations to the contrary made by Mr. Godan and the others were therefore unfounded. And then you say, it is therefore clear that the factual bases, plural, of the judicial criticism which led to these charges cannot survive a proper and impartial inquiry. Do you stand by that?
It is therefore clear.
In other words, what we've gone through, the factual basis, not the legal basis, the factual basis, and the other paragraph deals with whether you had malicious intent. You stand by the denial of those.
Yes, I do.
Okay.
If the impartial inquiry takes into evidence
Yes.
what I've
It
presented
means
to be.
impartial inquiry. Yeah. In other words, without, yeah,
Being
a fair
biased.
inquiry. Maybe let's put it like that.
Yes.
Okay. Thank you. All right. Now, the last issue, I have 7 minutes, so we're going to go very quickly through this. The last section deals with what I called charge number 10. That's the issues to do with human resources transgressions. You remember the harassment, victimization, intimidation, and so on.
Yes, I'm
Yes.
aware of the charge.
Since you are here and you are an employee, we would like to assist the committee insofar as you have any experience in this. Yeah. Maybe I'll just read your evidence to save time, and then you can comment. Okay.
Okay.
At paragraph 47, you say, to the extent that the public protector, the CEO and COO, and some of the executive managers all demanded extra effort and or performance from investigators to achieve the good outcomes which were achieved, this was not done in any manner which was calculated to be undignified or disrespectful of any person. Do you stand by that, or do you want to explain?
No, I stand by that. I don't need to explain. I think this was yeah, no, there's no explanation needed. There
Okay.
was
speaks for
PP
itself.
treated me specifically with respect all the time. She listened to opinions and gave input. So yeah, I've never seen her disrespect someone or hear her disrespect someone as well.
Yes.
So I can stand by that.
Yes. And Mr. Mataboge's evidence was that when there were differences of opinions and debates, sometimes she would give in to the opinion of yourselves and other persons. Have you seen that?
Yes, I have.
Thank you. Okay, then the next one at 48, it says, I also wish to confirm categorically that the vast majority of the deadlines which were being monitored in meetings such as Dashboard, which I also attended, were self-imposed by the persons being monitored. In respect of every investigation, the very first set of deadlines are contained in an investigation plan in which all the deadlines are populated by the author of the plan and not imposed from outside or above. Okay, this is quite important. Briefly, what is an investigation plan?
It's a plan on how your investigation will proceed. It will set out the basic details of the file number, date received, whether or not it's a same matter and a mere matter, the allegations, then the steps that you're going to do in the investigation. So communicate with your complainant. I'll just summarize. It can be a long list or it can be a short, depending on the complexity of the investigation. Yeah. It will include who you need to write to, who you need to have meetings with, who you have to interview. It will have your risk factors as well, which
okay,
yeah,
that's fine. That's enough
basically
for now. Yeah,
plan.
we actually have, if I had time, I would display one, but we don't have. But so for the purposes of the present, the gist.
Do you mind displaying that one? Do you mind displaying
Oh,
that?
thank you, Chair. Okay, now I've just been
time.
given, it's going to take us about an hour to do so. I'm joking. So, thank you, Chair.
Whilst Advocate Mphofu's doing that,
Okay, go.
Sorry. Oh, I thought you were helping me to find it.
I am endeavoring to do that. Are
Okay,
we talking
thank
about
you.
the investigative plan for
Yeah,
the SARS
any,
unit? No, I'm specifically asking for the SARS unit report because the witness would be able to talk to the very issue before.
Yes, if you've got, yeah, if you've got one, that would be even a bonus,
The
but I was
witness
looking
asked
for
it,
any,
But we haven't received it. That's why I'm raising it.
no, I'm looking for any investigation plan. In other words, the grid, even if it's plain and unpopulated, yeah. But anyway, if we find it, we find it. Thank you, Chair. I just want, let me not waste time on that. If we find it, we find it. But if we don't, we'll deal with it with Mr. Mataboge. The point really is not so much the content of the investigation plan. The point I'm driving at is the one that comes from your paragraph 48, namely that an investigation plan is something that you, the investigator, drafts. In other words, you say, I'll do this by such and such a date, I'll do this by such and such a date. And then you go to dashboard or whatever to present your own deadlines. And if you haven't met your own deadlines, then there might be a debate. But the point I want to make is that the original deadlines are self-imposed. Is that correct?
You can switch it on again.
Yes, self-imposed in line with the service standards.
Yes. Oh, yes, of course. You don't just put whatever you like.
Mm.
So if it's a mere investigation, obviously you'll have tighter deadlines and so on and so on.
Mm.
So
if it's a GGI, it will also have different deadlines. If it's
yes.
a service delivery matter, it has different deadlines.
Fair enough.
Uh,
So subject to that qualification that those deadlines would obviously have to conform with the what do you call those standards?
with SOPs, standard
Standard
operating.
operation procedures.
Yes.
But other than that, they are self-imposed, correct?
Yes, after the basics are done, so that would be which are your 30 days, 5 days. Those are standard. Once that those are completed, then you can try to figure out your own timeline in terms of how your investigation will proceed.
Yes. Thank
So
you.
yeah, that
No,
like,
thanks.
like any other plan, though, it does change depending on the circumstances of each matter.
Fair enough. Okay, thanks. Okay, I think that point is made. We'll, if we find the prototype plan, we'll display it quickly. All right. And then at 49, you say, even when new deadlines are set following the failure to meet the original ones, these are most invariably done after discussion with the affected investigators or official, and never done in a rude or demeaning manner. The aim in all cases is to assist the public. Do you stand by that?
Yes. Like I said, I can only talk about my experience with the PP. She's never been rude when I have not met a deadline, and the reasoning is suitable or understandable. We talk about a new deadline, what were the challenges, and what's the way moving forward. So I've never experienced such. I've never been in the presence of her doing this to another person as well.
Yes. Okay. And then you say that this has been your honest and personal experience at the institution. I'm certainly not aware of any culture of prevalence of intimidation, harassment, or victimization in the organization. Do you stand by that?
Yes, the charge was very detailed though, so yes.
Yes.
I won't go into detail because some of the things I was not a part of, and other colleagues that may have suffered who did not share such information with me, so I wouldn't know where, for example, Mr. Mahlangu
Yes.
went, etc. All of that.
No, that's fine.
Yeah. So,
it's
but I
understood.
was never intimidated, harassed, or victimized.
Thank you. And you met with the evidence leaders in July or August and shared your information of mainly some of the issues. We might have dealt with them in more detail now, but some of the issues that were raised with you, you gave information to the evidence leaders, correct?
Yes, information that was in my possession.
Yes. And is there anything that is fundamentally different that you said to them? Let's say then you said, no, we were forced to have a vendetta against Mr. Godan, which is material different, except for the fact that it's not, it might be more detailed now, different from what you have told the committee?
No, it is a long time ago. I won't recall such the detailed conversation that we had, but I don't recall stating those vendettas and having bias and being impartial.
Yes. Okay. Now, we're just rushing for time now. But I'm taking advantage of the chair's limited generosity. I know it's not a lot of it. So it's bundle H, item 31.2.2 is that form, Chair, that
But the funny way of taking advantage of the limited generosity,
thank you.
because it might end.
I know.
Okay.
So it's bundle A, bundle H, item 31.2.2. There's a saying, Chair, that says you must not look a gift horse in the mouth. Just take it as it comes. All right. Yes. Okay. That is, again, don't worry about the detail and what is filled in. It's just to assist the committee to see, because we hear all these terms and we don't know. At least it's better when you have a visual image of what it is. Is that what an investigation plan looks like?
Yes.
Okay, just take us through not in detail, of how if you got this thing in blank and now you are the investigator, how would you go about populating it? Take us through in 2 minutes.
Insert the file number, insert the complainant's name. If complainant wants to remain anonymous, we include their name, but this document is internal. So even if the name is there, we just put it in brackets that anonymous. So
Okay.
for the institution that is being complained against, the name of the investigator, the date received, as it's written there, that's how you fill it in.
Okay, can you roll it down a bit, Tsapo? Yes, I'm more interested in the time frames, yeah. So then obviously on the left-hand side, you have actions or things to be done. And
Yes.
the gist of what we were discussing would be on the right-hand side. That would be the deadlines, or
Yes.
let's call it time frames.
Yes.
Okay. So in this case, if you said action to be taken, decide how to deal with the complaint, provide complainant investigators details, finalize investigation plan, 5 to 11 July 2018. Then next.
Yes.
Next one.
Like
Next page.
this way, it will. This is against SASSA. Maybe time frames will be different. If each point will get a different date, it's not. You can do it like that, or you can actually put each task with its own date.
All right. Okay.
Okay.
Get the idea. Just roll it all further on. Yeah. Okay. And then right. Then the real big deadline is the last one, of course. We say then duration of the investigation. In other words, you have that deadline and then you work backwards. It is estimated that the investigation will be completed within a period of 24 months from September 2018 to October 2020. So that's your time frame now, the large one, not the specific one. And then it gets signed by, let's say, you're saying this gets filled by the investigator?
Yes, if seniors report to the chief investigators,
yes.
So it
okay.
will be.
So you as the investigator, you'd have it then signed by your senior investigator and the chief investigator?
Currently, because now investigators do report to senior investigators. Previously, when this investigation started specifically, and another colleague that was in GGI as well as an investigator. We reported directly to the chief investigator. We've never reported to a senior.
Yeah, no,
Yeah.
just in the normal course of events, or let's say as it happens now, if it was done by an investigator, would it have to go through the normal steps to senior investigator, chief investigator?
You must remember now I'm in the province, so we operate differently in the province. In the province, it's the investigator and the senior investigator that sign.
Okay, fine. Anyway, let's just say your reporting line would then sign it.
Yes,
But
your
the-
reporting line.
Yes. The point really is that then this is the blueprint from now on, as far as this investigation is concerned, you will then be judged according to that framework.
Yes.
Okay. Chair. Yes, thank you very much. I don't want to abuse the privilege I've been given by the chair, but I do want to say that I wish if we had more time, I think your evidence has been most valuable and informative, educational, and hopefully it will assist the committee to resolve some of the allegations that have been made. Thank you very much. And I might ask you one or two things at the end, but that will be on a limited basis, just for clarification. Thank you. Thank you, Chairperson.
Thank you, Advocate Mpofu. I did realize that you have placed a lot of emphasis on this witness and the issues you put, so the extra time is corresponds with that. You had asked for an extra hour,
Thank
and
you,
I've exactly given you that extra hour.
Thank you, Chairperson.
Just to indicate the fairness of the process.
Don't push it.
Thank you very much. Colleagues,
Thank you.
we will pause there for today. Thank you. We'll meet tomorrow at 10. Ms. Mvuyana, please go take a break.
Yes.
and the rest. It was a long day.
Thank you.
We're getting there. Thank you. See you tomorrow. The meeting is adjourned.
Thank you, Chairperson. Thank you, Ms. Mvuyana.